Home.
Welcome to our class.
ಏನು ಹೇಳಿದ್ರು ಯಾವ ಸ್ಟೇಜ್ ಕೇಳು.
Welcome to Traffic. Bluetooth mode.
Which matter? Fresh matter. Yesterday moved.
Fresh matter till 10.
My lord, kindly listed head of the list. Responded person are trying to convey the property.
Tomorrow.
My lord, Akash is running a Montessori school with 60 students in it. The respondent being the landlord is trying to dispossess the appellate. I moved the matter yesterday, however, unfortunately, it was end of the list.
Tomorrow. Verify, is there any office objection?
Office objections are complied.
Tomorrow.
My lord, right, end of the list.
Tomorrow, we'll see.
Fresh matter.
My lords, tomorrow, rejection.
Tomorrow, all matters.
Fresh matter.
Application under 39 rule 182 rejected.
Give it tomorrow.
The urgency, my lords, respondents are to dispose of the property, my lords, they entered into an agreement of sale during the pendency issue, my lords. They are entering into a deed of sale.
Tomorrow. When that injunction order has been passed. Then we are now that October.
Six party, my lords, tomorrow, my lords. Six party judgment, my lords, agreement has been filed. Yesterday, executing court has passed an order for registration of sale. Six party.
Tomorrow.
Today, the last was the date, they have not appeared.
What is that matter?
The matter regarding expert injunction order obtained. I filed an application 1 year ago, madam. Why I moved the matter?
My lord, the fresh matter, my lord, the same memo has been put online. It was given as.
Wow, what is that urgency?
IA got the unnumbered IA got dismissed.
Nobody has date court of position. Tomorrow. Yes, if it is compliant, it will come tomorrow. All matters will be taken tomorrow. Yes.
Page number one, serial number 1 to 4. Page number 2, serial number 5 to 12. Page number 3, serial number 13 to 19.
Serial number 15, my lord. I'm for appellant. Weeks time.
Ravindra Prasad P.
Please.
Lord, serial number 18, my lords.
Comply office objection. Yes.
Serial number 18, Ashari Joshi.
Appearing for appellant, my lords. Praise time for.
Yes. The request of notes for the opponent. Yes.
Praise time to file objection, my lords.
Yes, 2 weeks. Why you have all moved that matter?
We are not being served to the court.
Yes, we'll see that. Yes.
Grateful, my lords.
Page number 4, serial number 20 to 22. Page number 5, serial number 23 to 26. Number 27 to 30. Page number 7, serial number 31 to 37.
34. You are appearing for? Have you informed that other side? Inform and move. Yes.
Page number 8, serial number 38 to 45. Number 9, serial number 46 to 49. Number 10, serial number 50 to 60.
My lord, serial number 60, my lord.
Hmm.
Kindly out on after vacation. My lord. Serial number 60
60.
for respondent.
The
I appear
request
for
of
respondent.
serial number ಎಷ್ಟು?
60, my lord.
60 ಎಲ್ಲಿ is the respondent ಎಲ್ಲಿದ್ದಾರೆ?
Serial number 16, Manjulata Rayappa for petitioner Sudarake.
Sridharake, I appear for respondent.
Yes, at the request of counsel for the respondent. Please be seated.
Page number 11, serial number 61 to 67. Page number 12. Page number 13, serial number 68 to 70. Page number 1 for order, serial number 1. Concern and defeat for petitioner.
Complaint office objection, my lord, it's showing that office objection.
Non-arriving of defendant number 1
Yes,
to 3.
they are the defined before the trial court. Also, they are dependents. I am not seeking any relief against them. My lord. I have filed the application under order 7 rule 11. It is dismissed. As such, I will not arrange them as the party. They are the dependents. No relief is sought against them.
There is the plaint. Yes. Your defendant number?
4 2. Dependent number 4 5 6 7, my lord.
4, 5, 6, 7.
Please, my lord.
Suit for?
So for possession and declaration, they have filed, my lord.
You have had plaintiff as a party.
Yes, plaintiff is the party, my lord.
Yes. Respect of office objection for not arriving defendant number 1 to 3, 8 to 17 as a party. Submission of counsel for the petitioner is accepted. Office objection is overruled. What about others office objection?
Office objection, I have complied, my lord. I have compared the office objection, second office objection. It's the, signature.
No, what is that non-compliance of the above office objection arriving 8 to so and so? What is that office note? Office objection number 2. Defendant number 7 of the trial court is arrested. What is that name of the defendant number 7C is not correct.
Correct, my lord.
What is that name? 7C.
See, Saili, Soviya.
ಶೈಲಿ ಶೌರ್ಯ ಅಂತ ಎಲ್ಲ ಐತೆ ನೋಡಿ ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ. ಶೈಲಿ ಶೌರ್ಯ ಅಂತ ಇದೆಯಲ್ಲ.
Petition number 6, madam. 7C. Petition number 6, madam.
Petitioner number 6. Petitioner number 6 ಎಲ್ಲಿ ಇದಾರೆ? 5 ಮಾತ್ರ ಇದಾರಲ್ಲ. 6.
Okay, sir. Saili.
ಅಲ್ಲಿ ಏನು ಬೇರೆ ತರ ಮಾಡೋದು?
ಇಲ್ಲ, ಆ ಕಡೆ ಈ ಕಡೆ ಆಗಿದೆ. alias name.
Yes. ಈ ತರ ಹಾಕೊಂಡು. Submission of learned counsel for the appellant in respect of office objection is accepted. Office pose this matter for admission. Yes. Next week.
They have 32 days in filing the
Notice.
notice, madam.
Yes.
Your lordship, MFA is not maintained. Small brothers court, in lordship read up pass the order. Now, the last time, your lordship. And order 9 to 13 that it was admitted, CRP.
Then we have to file a writ.
No.
Yes.
It is CRP.
CRP ಅಂತ ಹೇಳಿದ್ದಾರೆ ಇದರಲ್ಲಿ.
How do MFA admit? MFA comes only for city civil court.
Yes. Now, what is this order?
Order 9 to 13 was rejected.
Present petition is under past judgment.
Same facts of the case, order 9 to 13. The office says under order 43 rule 1, I have to file the MFA.
Yes.
MFA not good.
Yes.
HRC will file HLRP under section 46.
Yes. What is that other office objection?
We and then nothing, your lordship.
What is that other office objection?
There is nothing.
Written representation ಆಯ್ತು. Non-compliance of the office objection.
ಮಾಡಿದೀವಿ ಯಾವ್ದಿಲ್ಲ ಆಫೀಸ್ lordship today execution case is there.
Provision for CRP to be stated correctly, provision for court fee paid in this court to be stated correctly, details regarding proceedings, trial court number and designation to be stated correctly.
See that there are 5 office objections.
I have read. Today execution case is there. I will comply today itself.
Complaint. Pass on.
ಯಾಕೆಂದ್ರೆ execution case.
I think comply that.
Serial number 3, Harsha.
I am appearing for petitioner in this case, my lordship. IA number 1/23 is for condonation of delay, but petition is in time, and hence I filed the memo for dismissed that IA number 1/23 has not pressed, my lordship.
Yes, I am one of 2023 is dismissed as not passed.
My lordship, the respondent have already filed the execution petition. I have already filed IA number 2/23 for stay the operating portion of the judgment, my lordship.
What
This
is
is the
this
suit for
matter?
ejectment, my lordship. My lordship, this is the suit for ejectment. There is no dispute regarding arrears of rent, my lordship. There are other 4 shops are there, my lordship. I am in the ground floor of shop number 1, my lordship.
Vacate the delivery and vacate possession of the food scheduled properties to the plaintiff within 3 months. Yes, you have been asked to vacate. What is wrong in that?
My lordship,
Wherein-
there is, my lordship, I have paying the rent up to date. There is no dispute regarding that. We
No,
are
if
ready
you
to
are-
settle, but
No,
there is showing
is there
some
any
third
bar
party.
for eviction if it is paid that rent regularly?
No, my lordship, but my
then-
lordship, the reason is there is some other person is showing interest to purchase, showing interest to come over that
Yes,
property, my
that
lordship.
is for
That's
the
why the
landlord
reason.
to deal with, mister. What is your right as a tenant?
My lordship, one opportunity may be
What
given,
they
my
have to
lordship.
do,
We
mister, they
are
have
ready to
to,
set.
landlord, they
lordship.
have to approach the court to vacate that tenant. After that also, you are saying that what you can do it.
My lordship,
That
but
you go. You give an undertaking before that executing court that take some time and vacate, mister.
my lordship, stay may be, till that stay may be given, my lordship. We are ready to talk with the owner.
Tell me what is wrong in that order?
My lordship, the reason is there is no dispute in us, my lordship. The third party is creating dispute. That's why the landlord is disturbing my possession, my lord.
No, yes, it is for that landlord to decide, mister. What is wrong in that? Tell me.
My lordship, there are other 4 shops. There is no dispute with them, my lordship. Only the dispute with me. My father was expired last year only. Then they started these all things as my lordship. Third party was
I
showing
pay
interest.
our
That is the
Indian
reason.
market landlord.
My lordship, we are ready to
They have
vacate,
to,
but we need some time, my lordship. That is the only reason.
You give an undertaking tomorrow. Ask your party to give an undertaking that we will vacate within 3 months.
My lordship,
Then you want to, not to vacate that premises even after he has obtained that. See, he has filed in a suit in that 2017.
yes, my lordship, 2017 they filed.
6 years you have enjoyed, mister, even after filing that. Yes. Take after vacation.
Till that stay may be
Yeah,
given, my
you know
lordship.
that
They have
roster has
already
changed.
filed the
You take
execution
after
document.
vacation. Yes.
Serial number 4, Anasa, MD for petitioner.
I appear for the petitioner in this matter. For the caveat. Suit is filed for partition or recovery of money by a husband against a wife.
Yes,
Not property is standing in the name of the wife.
yes,
She purchased this property from her mother and sister
yes,
in 2001.
yes.
Not
No, this is the rejection of plaint.
rejection 711.
Then why office has right that?
That's what under 711 will not.
It's a CRP only.
It's a CRP. If it is allowed, it becomes an RFA
Yes.
because it's a decree.
Yes, yes.
Otherwise, it's so.
My lord, there is a bar under section 19(5) of the Family Courts Act, where no appeal or revision is maintainable. There is a bar under the Family Court Act, it's a special enactment. In fact, section 20 says that it has an overriding effect. That no interlocutory order,
Yes.
any revision is maintainable.
Mr.
Because although it's a family court matter, it's not a matrimonial dispute, it's an OS. But please look at
That distinction is not there.
please have a look at the plaint at page the 23 annexed P.
It's a partition suit that is filed.
No, it is designated to that family court. Why that?
Because it's between husband and wife, but it's tried as an OS, it's not an MC case. Please look at it, OS 103 of 2019.
Yes.
It is being tried as a family, as an original suit. But if it's a matrimonial dispute, 711 will not apply at all.
Yes, yes. Oh, yes, that is what that.
That is why,
Now, why that suit has been filed in the family court? It is maintainable before the family court.
I mean, because it's between husband and wife, they have filed it there, it should have been tried
It's
in
maintainable. The OS regular original suits are filed in family court between husband and wife, even for injunction. Because section 10 civil procedure code applies.
Your lordship sees if the application had been allowed, it would have been an appeal, it would have partaken the character of a decree.
Oh, that is true. Yes, what is this matter?
Your lordship sees, my lord, please look at the plaint at annexure B. The petition plaintiff is the husband of the defendant.
Yes.
And at paragraph number 4, he says,
No, that why you have filed an application for rejection of claim?
because if your lordship sees paragraph number 7,
Yes.
I purchased this property from my mother and sister under 2 release deeds
Yes.
dated 2/5/2001. My lord gets that?
Yes, 2/5/2001.
2/5/2001, 2 release deeds are there. Next page is also there.
Yes.
Now, what he says in paragraph number 4 is that he arranged some funds
Yes.
to the defendant for the purpose of purchasing this property. And therefore, at page 28, paragraph 14, he says, not middle of the page, if for some reason the court comes to the conclusion, middle of
Paragraph?
14, page 28.
Yes.
If for any reason the court comes to the conclusion that equitable partition cannot be granted in such an event, plaintiff would be entitled to recover all amounts paid by him with interest. In such time, the amounts are invested, repaid, charge is created on the property. Now, the money is paid before the date of the release deed in 2001. Suit is filed in 2018.
Why it is rejected?
No discussion at all, my lord. Absolutely no discussion. One paragraph discussion is there. I have taken 2 grounds, my lord.
Yes.
First ground I have taken is that the suit is barred by limitation.
Yes.
Not earlier, the judgments of the Supreme Court were that limitation is a mixed question of law and fact, it can only be done by evidence. But prima facie, if the suit itself is barred by limitation, could he recover? Could he recover this money after 17 years?
Take the application.
Yes.
Page 32
So
of this year.
The court says you have not said under what specific provision you have filed, whether A, B, C, or D. But that is no ground to reject the application. Please look at the infused order, my lord. Only one paragraph.
Now that when the what is the stage in the suit?
All IAS now it is posted for hearing on
It's
some
for
IAS.
plaintiff evidence in the first week of December, my lord.
Now that it is posted as
Please,
December.
please. And then if I may just point out one
No, now
line.
that we'll have it after vacation. There is no, the order will be passed before that because it is posted in the
It's,
December.
it's in December. It may be posted after vacation, but
You
my
are taking
lord,
notice to R1.
please, I have filed KV.
Yes.
Only one defendant.
Only one different, only one respondent.
respondent.
Aviator is
Lord, may I
undertaking-
make one request? Lord?
Yes.
What has happened is, Lord, in my absence, he has obtained an order against me not to let out this property. And now he is using that against me. For last 3 years, I am unable to let out the property. Your lordship sees us ultimately, let us say, the worst against myself when he is entitled for a share. The property will be put to better use if I am allowed. But I am a lady. I have no other.
That is not the subject matter of the
No, no,
petition at all,
yeah,
my
I'm
lord.
only
That may not
asking-
be urged here. That may not be urged here because the only,
May I
to the
request-
limited extent, the learned senior counsel mentioned
Yes, I understand.
that it is, that there is no,
Yes.
that may
No,
not be
that,
necessary considering it's in December
because
and
the
it may be
only
posted
stay
in
can be
immediately after
granted.
vacation.
Only stay can be granted not to proceed further in the suit. No, but suit is now posted.
In December, my lord, it may be, a date may be given
Yes,
even
sir.
after vacation.
Yes, yes, right. Learned counsel for curator is undertake to appear for respondent number 1. In respect of office objection regarding mental is kept open. Read this matter on 30th October. Yes.
Please.
Serial number 5, clear Khalil Pasha for petitioner.
Yes, 2 weeks time is granted to comply the terms of objection.
Serial number 6, the party electrical for appellant executive.
2 weeks to comply the terms, 2 weeks to do needful.
Serial number 7, PS Venkata Subbarav for appellant.
Yes. Yes.
Compensation will be awarded.
No, that is the law. How can that? No, only.
Compensation awarded to every year.
Hmm.
The remaining portion, what was remaining amount will be. That shall be payable only after the determination.
No, see, now that whatever that amount which has been awarded by the land acquisition officer. Now that even that is there any enhancement in that appellate authority? Enhanced amount and the yes.
Enhanced amount of compensation for fees.
What is the law says? Law says you have to pay entire.
Before may not be no court fee was paid because it is always recoverable upon adjudication.
No, see, if there is any enhancement in that appeal before this court, for that we can say that it can be recovered after enhancement. But if it is already granted, that suppose no, if it is dismissed, your appeal is dismissed, then where will recover for that?
No, because enhanced amount is already there. This is only for further enhancement.
No, enhanced amount will not be there with the trust. It is there in that authority. No, all that. See, enhanced amount in this court, we can say that while granting that order, if it is enhanced, court fee can be. But others you have to pay because it is enhanced, you have to pay that, withdraw that amount and pay that court fee.
It's so called the enhancement amount by the court is already remitted to this one. 6,000.
So what is deposited before this court?
6,750. The enhanced amount of compensation for this.
No, you have to pay that entire amount, is it not? No, not generally, you say me on the law.
No, that is remitted only at the time of the recovery of the compensation. At the time allowed when they draw the decree.
Show me that any law that I don't think. See, suppose if there is an 20 lakhs has been granted by that LAC court, if you are seeking for an enhancement, for that we'll say for that enhancement it can be recovered only if it is this court has enhanced. For others, whatever that relief you are claiming for that, you have to pay the court fee. Where is that exemption? You show me that exemption if for the land.
No, there is no exemption as such. Court fee on the enhanced amount, my lord, is undoubtedly payable. But my lord, that is paid. That is paid, my lord, at the time of my lord, the recovery of the amount. Because my lord, we'll have
Where
to
is that discretion? Where is that discretion for the court fee? Court fee, it is not the discretion of the court, is it not?
Of course not, my lord. Therefore, my lord, and the enhanced amount. In fact, my lord, if my
What
lord,
is that court fee you have to pay now?
my lord, if section 49 is applied, my lord, while filing the appeals, lords would kindly take my lord page 34. The LAC proceedings, no court fee was paid. My lord, 49 contemplate. Court fee as paid, my lord, before the trial court is to be paid while filing the appeal. As such, my lord, no court fee is paid. So therefore, my lord, this concept of court fee in land acquisition cases, my lord, is only at the time of the award being drawn.
Under which provision they are asking for a court fee? That is your appeal memo regarding the court.
Page 12, my lord, para 26.
Well, So we'll add after vacation, we'll examine that. There is no urgency in that land.
In the sense, land losers, my lord, in fact, what is paid to the neighboring lands, my lord, it is not paid to
We'll
us.
see that. We'll have it after vacation. Please this matter on 26th. Anyhow, it is coming before me.
Please, I understand.
Because so many urgent matters are
I
there.
understand.
We should not waste.
I understand.
Yes, I appear for, my lord, so far as issuance of notice to R1, my lord, can be held sufficient, my lord. Both the respondent 1 and 2 are residing in the same address.
Yes.
Unclaimed at the
Notice issue to the respondent number 1, written with postal shara,
Unclaimed.
in service of notice to R1 is held sufficient.
Yes.
What is that 4 and 5?
4 and 5, my lord, depreciate stamp duty, court fee is paid, my lord, today morning, my lord.
Yes.
Notice to may be issued, my lord.
Yes.
Office may be directed,
Council for appellant has submitted that deficit court fee,
paid today, man.
PF has been paid today.
Yes, my lord.
Office to issue notice.
Great.
4 and 5.
As per my knowledge, there is an office objection with regards to deficit court fee of rupees 1060, which is already been paid on October 6th. To that effect, I'm filing the
Value
memo.
of the appeal to be stated correctly. Respect to that precedent additional market values. Case with related to the 12. That additional market value to be stated. There are other office objections.
I will carry out the same within the.
Yes, week's time is granted to comply the office objection. It's 2 weeks time is granted to comply the office objection.
This is complied with office of register. But the suit for partition is defined.
What is that office objection?
But my clerk had informed me that all the office officers have been complied. So we are not aware of it.
Many office objections are there. Verify.
Weeks time.
Yes.
It will be taken after vacation.
Yes, 2 weeks time is granted to comply the office objection.
These are on the last date of hearing, my lords, but the objection is still,
Office objection, acknowledgement having surveyed. Copy to the caveat.
last date of hearing only observed the
Copy
copy.
served. Yes. Learned counsel for the caveator has submitted that he has received the copy. Hence office objection is overruled.
Yes.
Ready?
Yes, ma'am.
What is this?
NFA is, my lords, challenging the order passed by the trial court in miscellaneous petition. 25131 of 2016. The miscellaneous petition is filed to restore the OS suit which was dismissed for non-prosecution.
Suit is dismissed. You are the plaintiff.
Yes, my lords, I was the plaintiff before the trial court. I will file a suit for declaration and injunction. What happens is, my lords, after framing of the issues, on issue number 3, the suit came to be dismissed. Against that, I will prefer an RFA before this honorable court. In the said RFA, my lords, the matter was remanded back to the trial court for fresh consideration. What has happened, my lords, after the remand, my lords, I have not received any notice. And since for that reason, my lords, I did not appear before the trial court and the suit came to be dismissed for non-prosecution. Against that, I filed a miscellaneous petition.
Why miscellaneous has dismissed?
Miscellaneous petition was dismissed at page number 32, my lords.
What happened, my lord?
Page number,
Let him complete. Yes.
page number 32, my lords, of my petition.
Yes.
Paragraph number 30. Though she claimed that the notice of original suit after the matter was remanded by the honorable court was not served on her, but the very fact that after the
Paragraph, Kara?
paragraph number 30, page number
Yes.
30.
Yes.
Though she claimed that the notice of original suit after the matter was remanded by the honorable court was not served on her, but the very fact that after the dismissal of OS number so and so for non-prosecution within 6 days, she filed this petition shows that she had knowledge about the matter pending before the court, but she do not come before. She see that after the matter has remanded by the Honorable High Court for 3 years, she do not come before the court, and after dismissal, he files this petition so that she can, after restoration, again prolong the matter, which cannot be entertained. Hence, I hold there are neither any bona fides nor any sufficient grounds for restoration of OS.
Suit for?
This is a suit for declaration and injunction. I will file it against the respondent. Against that, my lords, there will be 3 issues also framed. On one issue, it will be considered.
No, you are appearing for that corporation.
Yes,
Yes,
my
my
lords,
lordship.
corporation.
It is issued. If it is delayed, he will be affected. What will do?
What is happened, my lordship? Not only this file in the suit, my lordship. Initially filed 2718 2007, it is dismissed. Again, I came to the RFP remanded back. Again, one more suit is filed, one more appeal is filed 8/17 2016. The approach from the KIT. That is a reminder back. Again, one more suit is filed 8526. That is also dismissed. Again, one more appeal is filed. That is also dismissed. Writ petition is filed. That is also dismissed. Writ appeal also filed. That is also dismissed.
My lords, that is
See, my lordship,
another
yes, sir.
proceedings.
Therefore, I place that, my lordship, where we are challenged before the KIT also.
That is a
KIT
notice
separate.
issued by the respondent. Against that, I will challenge it before the KAT.
Yes.
Not only.
What
this,
is-
my
On
lordship.
one occasion, I will challenge it, my lords, I will withdraw. On the second occasion, I will challenge it before
No,
the
where-
KAT. That
this is
came to
18
be
years
dismissed.
case, my lordship,
That
18
came
years
to be
there are
dismissed.
after matter.
Against that, I will file a
After
writ.
one case filing interim are getting, then again the.
That is a different proceeding.
I'll place that, my lordship.
No,
Which is-
that in the suit, is there any injunction? Is there any interim order in favor of that plaintiff?
No, my lordship.
Then we.
All I request is, my lords,
My
I
lordship,
give
can you see that
I
which has
will-
filed by the Supreme Court, my lordship.
You produce all.
Yes, my lord.
before that trial court in that OS,
Everything has produced, but that's what the court is dismissed, my lordship.
Not
Everything
on
has
that.
produced that.
not on that.
My
ground.
lordship, kindly see that I place that. The Supreme Court is passed, the writ appeal also dismissed.
Yes.
That is a different proceedings,
No,
my
no.
lord.
Yes,
What is the different procedure? It is the same challenge, the same settled notice, my lordship.
Yes.
Kindly see that the Supreme Court is approved, observation, my lordship. The
Yes,
writ
yes,
appeal, my
we
lordship.
hear. Here has undertaken to appear for respondent. Robrera,
Yes, my
Obrera,
lordship.
sir.
yes.
He has approached for writ petition also dismissed, writ appeal also dismissed.
You file it in that counter.
Yes, my
It
lordship.
is matter after 2 weeks. Yes.
My lords, tell them, let them not precipitate demolishing the
How,
building.
how can
It is
that
a-
your suit is dismissed?
Ah.
How can you see that they are not demolished? That is a separate under statutes. This cannot be missed.
Now they are come, on the basis of this dismissal, they are coming the property
no,
and
No, no, it's
demolish.
wrong submission, my lordship.
They are, see, exercising that power under that Corporation Act. If he is not correct, you challenge
Yes,
it by
Lordship.
filing a writ, not in this suit. You don't take this advantage. That too before this court, yes.
Civil number 13, Sampan Tan, City for opponent.
For the. Respondent.
Yes.
Now plaintiff's appeal, my lord.
Submission regarding that.
Now, this is not kindly turn to page number 198. Now, what they say is in support of the interim mandatory injunction I saw before this.
98.
198, this is our suit for permanent injunction. I am the absolute owner of the property.
Yes.
Now kindly see heard counsel for plaintiff on IA number 1. He has filed a memo producing copy of sanction. The suit for bare injunction filed by the plaintiff against the defendant along with the plain copy sale deed dated 16/11 is produced under which the plaintiff and defendant have jointly purchased the suit property. Also, copy of the release deed dated 13/2/2015 is produced show that the defendant has released and relinquished his undivided share in the suitable property in favor of the plaintiff. It is a case of the plaintiff that in view of the relinquishment, the plaintiff became absolute owner of the suitable property and has put up construction of multi-story building in the suitable property, and defendant is now interfering with his possession and hence the suit. At the time of arguments, counsel for the plaintiff has shown original documents whose photocopies are produced and originals are returned to the learned counsel. At this stage, considering the release deed dated 13/2/2015, executed by the defendant himself relinquishing his undivided share in the suitable property, plaintiff has made out a strong prima facie case for grant of interim order as prayed for in IA number 1, and there are sufficient averments that in case notice issued, the very purpose of granting injunction is that now there is an interim order of injunction granted in my favor. Thereafterwards, my lord, he seeks in my suit without there being any counterclaim. It is an admitted case that pursuant to that release deed dated 13/2/2015, his definite case is that on 19/6/2015, he enters to purchase a property. 19/6/2015 in respect of an apartment which I have constructed after the cancellation of GPA and after relinquishment of that, I have constructed the apartment, and he has entered into an agreement of sale on 19/6/2015. And he does not specify it is yet to be constructed and is not paid any payment in respect of the agreement of sale. Now, the trial court, if your lordship sees the order, In my suit, my lord, it's a suit for injunction, permanent injunction. I have got absolute title. Trial court has granted an ad interim order injunction. He further in the very order sheet, it is clear that he says by virtue of one receipt, a gas voucher, he tries to establish his possession in one of the apartments, that is flat number 29 in the 6th floor. In fact, he is under agreement of sale. He has not even made payment. He has not even occupied any portion of the suit shell property. Now, without there being any clarity, in my suit for permanent injunction, he is allowed to enter upon the property in respect of 29, flat number 29, under the shelter of the court, and the court goes to the extent of granting him police aid. And now, by virtue of that, he enters upon 29 and he is squatting over the property. Now, kindly see, this will be clear from order sheet page 200. Counsel for the defendant has filed. First, it grants injunction. Defendant also memo enclosing 2 affidavits of the person said to be neighbor and another suit of the suitable property, and also produced memo producing 11 documents. At this stage, it is brought to my notice that so and so has filed wakalat for defendant 1 along with the advancement application, but in the order sheet at 94 by inadvertence, the wakalat is not taken. Counsel for the plaintiff has filed affidavit of the plaintiff and list of documents with the 3 documents. Heard both sides, further IA number 1 and request of defendant 1 to modify the interim order granted earlier to protect, kindly see his total possession, protect the possession of the defendant in respect of a flat in the 6th floor of the suit shell property. At this stage, from the documents produced today, mainly gas bill dated so and so, which shows that defendant is in possession of number 29 SRT square 6th floor, and also from Bestcom document which confirms the possession of the defendant in flat in the top floor of the suit shell property, and from the contentions taken by the plaintiff himself in reply notice, which is produced as documented. It is prima facie appears that the defendant is presently in possession of flat number 29 in the 6th floor of the apartment complex constructed on the suit shell property, and accordingly IO granted earlier dated so and so is modified, holding that the plaintiff shall not interfere with defendant's access and possession to flat number 29 in the 6th floor of the scheduled property and car parking area and all. Now, virtually by virtue of the interim order of this on the trial court, he has been allowed. Kindly, I have produced the agreement dated 19/6/2015. Yes.
I may only submit. I don't have a copy of the papers.
No, now he has not even kindly see, he has been watching. Now, ultimately, my lord, there is a virtual interference. Now, I have got an order of injunction, and even according to the decision of the this full bench decision, he cannot now. There is not even a counterclaim, and there is an admission that my title is absolutely admitted because he claims under an agreement of sale. I have produced that is 19/6/2015 agreement. I have produced. Kindly see the schedule only. Then your lordship may guide it. And there is a cancellation of GPA, and again he. Kindly see, my lord, I have produced the 19/6/2015. At page 154. This is a type 154, typed copy of the agreement of sale between the plaintiff and the defendant. I am the absolute owner. Page 154, my lord. This is dated 19/6/2015. Witness as follows, whereas the vendor is the absolute owner of all that piece and parcel of immovable property.
The agreement, have you handed over the position?
No, my agreement, it is, he has not even paid one of the any of the terms of the payment. Now that is why, my lord, he admittedly, as on the date of suit, I am the absolute owner as per his own agreement. I mean, sale agreement. Kindly see the absolute owner of the suit shell property, and you let us see the schedule also, my lord. Is that it's a to be constructed property, which is at page. Kindly 171.
Yes.
And the property intended to be purchased by him under this at page 172. Description of the apartment to be constructed. Kindly see. Now, as on the date of suit, my lord.
2015.
2015. Now, I have the trial court has rightly granted him an injunction because he absolutely concedes my ownership and possession. Now, if at all, the flat number 29, which he says, it is totally different, 1,600 square feet to be constructed, and none of the payment made therein. There is no, admittedly, there is no suit for specific performance. There is no counterclaim. And now, by virtue of the interim order of the trial, which grants you injunction, then it modifies on the basis of a gas bill, my lord. It's a voucher which has nothing to do with the possession. How can he say by virtue of a gas bill, he is in possession of flat number 29? Now, then it grants him police protection. He enters upon the property. He meddles with the property. And that is why now this office objection, now here also, and finally, my lord, the trial court now says, since you go to the, now it is my injunction, I am the absolute owner. The observation of the trial court in this impugned order, since he is in possession, it is under the garb of the trial court order, is in possession, and it now drives me to file a separate suit to evict him. When he, during the pendency of the seat, he enters, my lord, kindly see page 61, my lord, I will point out that how it is, the trial court has, kindly see page 62 impugned order, operative portion from the 61, my lord. In other words, the possession of the 20% over flat number 29 paint house in the 6th floor of the social property along with the basic communities, everything it extends, my lord, without there being any payment. And water connection access thereto, including access by lift to one car park is not in the basement, is protected till the disposal of the present suit, and the plaintiff is restrained from interfering in the defense possession of said flat number 29.
What is that amendment you have filed?
Now, now what is required by the office is, now that kindly see, however, it is made clear that this order shall not come in the way of the plaintiff seeking. I have to seek during the pendency.
No. See, what is that amendment?
Amendment, I am not saying that he is in possession. His possession is illegal, and he is not entitled to take possession because even under the agreement of sale.
No, what is that IA number 6 filed by the plaintiff under order 6 rule 17?
He seeks modification. Now the modification is earlier. The trial court has granted to me.
What is that order 6 rule 17?
Order 6 rule 17, it is allowed. That is only, I am not saying that he is in possession. He is not entitled to occupy flat number 29. Is my prayer in the amendment application.
Where is that application?
I am not seeking for eviction, my lord. I am
seeking for eviction.
Yes.
Let us see that.
Pardon, my lord.
No, I will see that. What is that amendment now you have filed?
I don't have it. When I have it tomorrow.
Yes, we see that. What is that?
Yes, I will. Tomorrow.
Be a copy of the papers.
I will provide that because he is not entered any caveat, but I am ready to provide.
No,
Only one submission I want to make. The contention that he is taking that I have entered possession post the interim order was argued before the trial court. Trial court has noted that there is no averment in any of the IAs or objections filed to this regard. It is a new contention taken.
No, how you have entered the possession of the
through the agreement, my lord.
No.
Let me submit.
Wait.
Yes.
Where is that in the agreement showing that possession has been
even if I have an unauthorized possession, my lord, I have been
how you have entered
through that agreement, my lord. This is an apartment, if I may submit, a building which was purchased by me and him first together. Thereafter, owing to some requirements, he is a politician. He asked me to execute a release deed. I have challenged that document. That is a separate matter.
See, I am only in the respect of possession.
Correct.
You show me that your possession. How you
I have even built my house. I produced my pictures also. I am living there. I built a house in my apartment. I produced pictures before the trial.
That apartment is built by both of us.
No.
Both of us.
We were the joint owner.
I am the builder.
1 minute.
Let me
16/11/2013, we jointly purchased. 13 to 2015, he relinquishes that. Thereafterwards, he enters into an agreement of sale in respect of one apartment measuring 1,600. Now, under the garb of the interim order, he gets into the property. As your lordship was pleased to pose him a question, how and in what circumstances he has entered, except under the garb of the interim order of the court, he has no locus standi because the court, that's what court says, that I should have pleaded when he has entered into an agreement. Even in the amendment application, I will place before the court. Right tomorrow, I have not admitted his possession.
Court records.
No, under which law it permits to grant injunction in your favor without your application under order 39. 39 1 or 2 for the defendant.
Full bench decision is clear that I cannot file an I under order 39 rule 1 and 2, but it reserves the liberty for the court under 151 to protect the defendant interest if the circumstances need. And that is the provision that is invoked.
No,
I have not filed an I on order 31.
39 1 and 2 only in the B is concerned can also file. Otherwise, you have to file in a separate suit.
Correct. That's very clear.
You can't do it that.
I have not filed an I under order 39.
Then
that
how can that
distinction?
How can that injunction granted to protect?
Can you see the full bench order? Can you see the full bench order? It is permitted, my lord.
Yes.
Full bench only prohibits me
from making an application under order 39 rule 1 and 2 if I have not filed a counter claim. But the third recital in the summary of that, and I'll read, in cases do not fall under order 39 rule 1, which is where I come under, the court has the inherent jurisdiction to grant the relief injunction in its discretion if it is satisfied that such an order is necessary to meet the ends of justice or to prevent abuse of process of the court, and nothing is forced to limit others affect inherent power. It is that provision.
No, that is 39. It is only for the plaintiff.
Correct.
You see that?
Yes,
He has say it is for the plaintiff.
my lord, see the previous
Court
point
cannot-
summarized.
Yes.
Previous points clearly delineates when you can file. Under 1, 2, 3, the full bench is summarized. I don't have an extra copy.
It is here, I can. Lordship, I have the judgment. Only 1A.
1A, I bow down to that. I'm not filed under 1A or B. This is an inherent power the court has invoked on its own, and that is what the position of the full bench is.
Where is that, Mr. Under 39 rule 1 and 2?
Well, this is the decision of the full bench. I will
No,
just,
you show me that law first.
I just pass.
I have got the judgment.
Can you see? my lord?
Last,
They have summarized this.
6052, my lord, very clear.
Can you see the last page?
6052.
They have summarized para 33.
Yes.
Correct.
Both the plaintiff and defendant can maintain application under 39 rule 1A of the court. Second point. Insofar as relief under 39 1B and C is concerned, such a relief is available only to the plaintiff, and the defendant cannot maintain an application for the said relief in a suit filed by the plaintiff, irrespective of the fact that his right to such relief arises either from the same cause of action or otherwise. However, the open defendant maintains a separate suit. So insofar as 39 rule 1 and 2, point 1 and 2 have discussed that. Now kindly see point 3.
Yes.
Insofar as cases do not fall under order 39 rule 1, which is what I am under, the court has the inherent jurisdiction to grant relief or injunction in its discretion if it is satisfied that such an order is necessary to meet the ends of justice or to prevent abuse of process of court. That is what is being protected here, my lord. It is not under order 39 1 and 2.
Now, what is that 3?
That the full bench has analyzed the law of several decisions, and this is the summary.
Not fall under that 39 rule 1 of the court. Court has an immediate jurisdiction. There is a discussion in this aspect regarding that.
The law on whether a defendant can seek relief under 39 is elaborately discussed in several judgments. North Seas page 6033, it starts there. For contra, learned counsel defendants. In that case, order 39 was filed.
Yes.
Supported the order passed by the appellate court by arguing that when the case of the defendant does not fall under 39 rule 1C of CPC, circumstance called exercise the inherent powers, court would exercise the same to grant relief, and that would rightly granted temporary injunction in favor of the first defendant as prayed. That is the contention taken. In that background is the point 3 that has been made,
What is that?
which I read out as a summary. My only submission, my lord, this evening.
No, see. Learned counsel for the defendant supported the order passed by that applied court by arguing that when the case of the defendant does not fall under C of the CPC circumstance. Court would exercise the same to grant the relief. Appellate court has rightly granted a temporary injunction in favor of the first defendant as paid for.
Yes. The only question before the court on the first page is whether under 39 1 and 2, defendant can maintain an application,
Yes.
which is what the court says I can't.
Yes.
But in considering that, the court carves out an exception in point 3 saying nothing is stopping the trial court under 151 if the circumstances warrant to protect. And this is exactly the case here. He comes before this court, before the trial court. He suppresses the fact that I am in possession. I built my house. I am staying there.
Where is that document to show that you have constructed the house after obtaining
And I
that?
produce pictures, my lord, before the trial court.
Picture is not that. You have to
No, it is a
construct the.
penthouse. It is an apartment. It is a penthouse. I have been staying there.
No.
And he admits I am in possession in his pleadings. The
No.
trial court notes that also. Can you see the impugned order? On that basis, the injunction is.
Where is that is pleading? Show me that plaint.
Page, I don't have this pleading, but I have the extract.
Your
Can you see the impugn order? Impugn order, page 14.
About my admission, I will clarify.
No, let me submit, let the court see, page 14 of the, I don't know, page,
It's an IA.
the final order, page 14,
Yes.
that is the basis. Previous page, Manas, it starts, Malat, see, however, I am unable to accept the argument because certain vital admissions made by the plaintiff himself in the objections filed in the suit. In
No,
regard,
where you are reading? Impugn order,
impugn order, para 19,
para 19. Yes.
at the bottom.
Yes.
Unable to accept his argument because of certain vital admissions made by the plaintiff himself in the objection filed in the suit. In this regard, firstly, reference name made objection by plaintiff to IA number 2 dated 16/6 para so and so, wherein stated as follows. Plaintiff with great respect and also law abiding had obliged the order of the honorable court, provided basic amenities and never interfered with the possession and enjoyment of the penthouse, but defendant is using the property stated to interfere with the day-to-day affairs and also use the threatened work to dire consequences. Etc.
It sees a disobedience after police.
Wait.
Kindly see. He being illegal occupant, he admits I have an occupation. Then the next para 20. Defendant who is an unauthorized occupant is using electricity for residential purpose and also operating lift illegally.
This is extracted from the plaint.
No.
From his
It is
objections.
an IA. He has filed an application after the police protection. He entered into the property and he files a order 39(2)(a) disobedience. At that stage, I said, because under the protection of police protection, he has entered. So in that context, while filing objections to that, I have filed it.
No,
It is not borne
He
out by
never
any
said,
pleadings.
by virtue of the order, I comment that, and can you see the next paragraph now? That's what the content trial court notes. The same point is argued with the trial court, and my learned friend had nothing to submit on that point. Trial judge asked him, show me where you have stated that by virtue of the interim order has come into possession. He conceded, I have not stated anywhere.
No.
Can you see the next page?
Yes.
Page 15. Come to the learned counsel plaintiff that the defendant has come to unauthorized possession of the said penthouse under the shelter of interim orders passed by the court dated 20th April 2023, that is subsequent to the filing of the present suit and on the basis of orders obtained by this court. However, nowhere in the records has the plaintiff stated in writing any such contention that defendant has come into unauthorized possession after filing the suit and under the shelter of the interim order. It is a new contention taken. I've even filed affidavits of my neighbors to show that I have been staying there.
After the
No,
pleadings.
that you maintain status.
No, after the, you'll not.
Well, in
One
fact,
minute.
the interim order.
I will. This particular pleading, now the plaint is filed, written statement filed, no counterclaim. Now the learned judge is pleased to say that there is no pleading. Now after the written statement, there is no further pleadings. Now all that whatever that has been extracted is that at the time of he filed an application under order 39 rule 2A. Accordingly, I filed an affidavit which I can place on record the
No, now that you maintain status quo, whether he is there or not, now I cannot ask him to go out.
No, that's not to the, now, your lordship may kindly see.
In fact, my lord,
1 minute, the trial court
He is
says, no,
already-
kindly see, the trial court now says that I should file a suit to evict him. When he has, that operation of that order may kindly be stayed.
That is not correct.
Correct,
That is
my
for
lord.
you to-
There's a judgment of the Honorable Supreme Court that until
that
he has,
is-
wherein it
Now,
says,
Lord,
he
is-
cannot, now when I am in lawful possession.
See,
It is a
that will clarify when disposing of this appeal.
Hmm.
Now that you maintain status quo, we'll have it after vacation.
So
Then we'll decide
Yes.
whether that final.
there is one more, kindly see, there is one more afterthought, by way of an afterthought.
All
I
that in the trial.
have filed one more appeal.
See, in the trial, court will be decide whether he has in the possession before filing the suit.
yes.
Because it is only suit for injunction, what you have to be established that as on the date of filing.
I am
the
in
suit.
lawful possession,
If you prove that he has entered after that, then
definitely,
it will go. Otherwise, that you have to file in a suit for.
correct.
That,
It is 100% my lord, has having regard to pleading.
that can be decided by one.
That's what
trial.
your lordship, in the appeal only, there is one more appeal, which your lordship fix a date, I have filed, wherein consequent to this, my lord, he files a suit, now cancelling, by way of an afterthought, I filed suit on 6/4/2023, after all these order modification, police said everything, he enters upon the property. Then he files a suit declaring that relinquishment, which is a registered, that is null and void. In that, he restrains me from alienating all the apartments. How can this be done? That also I will get it posted along with
No,
this.
what is that? What has happened to that suit?
In that suit, there is one more interim order in his favor, wherein I am restrained from alienating any of the apartments situated in the plain property. This is the worst. I mean, first of all, he is protected. He was allowed to enter upon one particular apartment without there being any description. Now, office
There is
objection.
material for that.
Kindly see, office.
Now that suppose if suit for relinquishment deed is allowed, then he is entitled for the share in that
Yes.
property.
No, that's what, no, your lordship may kindly see.
Ultimately,
No, kindly see what is now that even very prayer, when that readings come before the South Court, you are all. Now, this is not the way. I should not be now even assuming that 1,600 square feet. He asked for penthouse. I may, during the pendency of the suit, I may allow him to stay in 1,600. Even as per the agreement of sale, he has not even paid anything. Now that also. But this kind of interim arrangement allow him, and he says photographs he produces, he meddles with the common property, lift, power, generator he replaces. All things I will place on record.
The reason I had to file for civil disobedience is that after the interim order was passed, despite that, Gundas have come, I have filed photos. They have dismantled, they have removed the lift.
Who has
engine.
dismantled that cannot be established in the photograph?
yes, so how many respondents are there?
Only one party.
Yes, party.
Yes.
Yes, you take notice.
I take notice.
Yes.
But only one submission, the order as is grants him an injunction so far as the entire building is concerned. That's what the interim order, impugned order is. It only says insofar as this flat on the top floor is concerned, you shall not disturb his possession because he has demonstrated. That is the order, my lord. That is the status quo in fact. I am not asking for the whole building.
No.
Only in fact, so
In
far
this
as the last flat. Can you see the order?
Now that the flat number 29, he himself is not sure. Now, under the garb of the sort, he is enjoying the penthouse. And he also says that he should need a car parking and all facilities. I have not even occupied none of the 29 apartments. Nobody has occupied.
See,
He is permitted. He is enjoying in one this thing.
Now that only grievance is that the court giving a finding that you have to file an eviction
It is.
petition.
Yes.
That we will consider after vacation and we'll see.
Yes.
That part of that order has to be required
Correct.
modified.
And also, he doesn't, according to his own agreement of sale, he has no vested right to reside in a particular apartment. Now, at his whim and fancies, he says penthouse is mine, lift everything. That's what it will be clarified from the other suit also when it gets
So
connected.
here, only you sought for a suit for injunction. Only regarding the possession, court has to be decided.
Correct. Well,
If you prove that
possession,
you are in the possession.
Court cannot make any case in his favor. Here is a case. By virtue of an interim order, the court has made a case.
No, that
It
is-
is not his case at all.
In fact, the court has said.
Except your lordship was rightly posed the question. How did he enter upon a portion of the apartment?
Will decide.
Where is the document, my
That
lord?
has to be decided with evidence. my lord.
What evidence? Here only, it cannot be mandatory, interim mandatory injunction of sort.
Yes.
Court has to do so.
Yes.
think.
So and so
That-
take to appear for respondent. Use this matter after 2 weeks.
Date 30th or 31st.
Second November.
Yes.
Grateful, yes.
I received a copy. I filed rejection. My lord, but this has the history of 30 years litigation.
Yes.
My lord,
What is that office objection?
I'll comply with the office.
No, you want style. What is that urgency?
My lord, so what has happened is, suit for partition was filed by the defendants way back in the year 1991. The same was dismissed and it went up to Supreme Court and finally it got culminated by dismissal in SLP in the year 2013. Thereafter, my lord, the mother of defendant number 1 files a suit against the suit schedule of land in 55/4. Therein, under that suit also, the defendant number 1, respondent number 1 comes as a legatee before the court. The court rejects her claim and that suit was dismissed in the year 2019. Land in survey number 55/4 has been declared to belong to the plaintiff, father of the plaintiffs. Plaintiffs, appellants partition the land, and insofar as 3 houses were constructed by the father of the plaintiff, and it is an admitted fact that plaintiff's father had put the defendants in possession of the property since they were brothers. Admitted fact, my lord. It is recorded.
It's not admitted.
Court gives a finding with regard to that. And now I file a suit for eviction against the defendants insofar as the house property is concerned. Now, what the defendants come and do here is, they come and file a suit for counterclaim for adverse possession. My lords, the property which is behind the suit schedule property, I have got secured kata, I have secured license, sanction plan license, I am putting up construction. Now, by virtue of adverse possession, till 2019, they fight against me, claiming they're joint owners. They don't admit, even today, they don't admit me as the owner of the property. Adverse possession they seek against me.
There is no animosity between myself and the defendants. There is a finding to the effect that I have put them in possession. The trial court also.
Now, what is that application he has filed?
My
He has
lord,
filed a 30 application under 39(1) and 2.
What is
See,
that?
my lord, he is restrained from putting up any construction.
my lords, I have invested. huge
Property,
amounts, my
status
lords.
quo should be maintained in the property.
My lord,
That's what the order.
photographs are there.
See, position is not disputed.
Yes,
I am
my
in
lord.
possession of the property, my lord.
I am the
possession of the
owner, my
property.
lords. I am the true owner. I am the true owner. They are not admitting that.
My lord, he has
At
produced
what
only
position
pick
they
and
are
choose documents.
Now, where is that your application for injunction?
Yes, my lord.
Where is that application for injunction?
It is at IN number, page number 145, my lords.
Defendant's application. In respect of
Defendant's
return statement, scheduled
Yes.
property.
145.
5 my lords.
145.
Annexed Q.
Because my lord, there are a number of documents available in the trial court. I have to produce documents, my lord.
No, is not to put up Allah. It is that injunction not to
Injunction,
interfere.
not the present, my lord, why I filed this application, he is trying to put up construction on the vacant space. No, by the taking advantage, my lord, this vacation, my lord, they are local politicians. They have access in the
They are
BBMP.
not,
No,
they are
everybody
not, my lords.
Everybody is
They
politician.
have, yes, they have lost
My
up in
lord, my
Supreme Court.
submission is,
My lord, they have
No,
lost
that
up.
they are,
they want to change the nature of the property.
Yes, my lord.
Are litigating this.
Allah, my lord.
No, no.
Last matter also they said, I don't know, in all cases, they are all politicians before me.
No, they are making
No,
allegations.
my
I
lord,
didn't
my
say they
submission
are.
is this. My possession is admitted in the scheduled property because for the last 30 years, they fought denying my possession of the property. Now they have come up with a suit claiming my possession.
I
For
did
the
not
last
fight, my
30 years, my lord, I can show on
Know
record.
that, have you obtained the plan for construction?
Yes, my lords.
After
Yes, my
filing of the
lords.
suit, my lord.
No, my
After
lord.
filing of the suit.
My lords,
After
I
I
have
filed the
obtained
written
plan,
statement.
I have put up construction, I have produced it, annexed page number 92.
No,
my
that,
lord.
what is the document to show that you are in the position as on?
My lord, the 30 years litigation itself speaks that it's an admitted fact I'm in possession of the property.
What is that documents?
No, my lord,
Is
because
it in- is it in
previously-
Bangalore?
Bangalore, my
Yes,
lord.
municipal corporation.
No, presently the property has come within the limits of BBMP, my lord.
BBMP.
My lord, when
Kata
the
stands
suit
in
was initiated,
Kata stands in.
but after filing of the suit, they got the kata from BBMP. After filing of this present suit,
Before filing the suit.
it was an agricultural land.
No, my lord.
Presently, for
No,
the
my
last 30 years, during the course of these 30 years,
No, my lord, it's
property
not
has come
a-
within the,
No.
Degree speaks, my lords.
No,
it was an agricultural land, man. Presently, it has come within the jurisdiction of BBMP.
when the suit is filed in the year 2023.
Yes, my lord.
Look, they filed a suit in 23,
Now,
but
in the
then
year 2022, Kata stands in whose name?
nobody's name. It is
No,
after filing of the kata, they got kata.
It was stands in whose name, Mr.
It was standing in the name of my father, my
My lord,
lord.
it's all.
We have
created
got
document.
it
My lord,
partition.
it was an
It was
agricultural.
not there in their
My lord,
name.
my submission is this. From 91,
Wait. See, when that documents, if you are saying that Kata is created by you,
my lord, this
I
is
will
not,
challenge that.
my lord, this is not the
You
litigation.
are not challenging.
No, my lord, it has come to my knowledge. I have to file an appeal now. No, they have created later after filing of all these suits.
No.
Without my
From
notice.
how many years it stands in your name?
My lord, my
From the
submission.
date
is-
of 1966, my
What are
lord.
you doing all these days?
1966.
See,
My lord,
injunction can be granted on the basis
no,
of.
it's, my lord, it has
They don't
history
have
of
any
30
document,
years,
my lord.
32 years, my lord. It has history of 32 years.
They have lost up till Supreme Court. Their suit they have lost.
That is the.
Their suit they have
I am
lost.
taking-
So again, taking advantage of
Mine
that.
is not
degree.
allowing me to speak, my lord. It's not my, I need time. I'll file objection with documents, please, my lord.
My lord, sir.
Because of 30 years history, I cannot
My
speak
lord,
in 2
kindly
seconds.
peruse page number
In 2 sentences, I cannot.
95, my lord.
Yes,
95, 96. I have put up substantial construction. Even my material is getting
No,
damaged.
my lord.
Where is that? Show me that.
What, my- at the page 96, my lords.
No, it's under construction, mister.
No,
Yes,
my
my
lord,
lords, I have
they
put
have
up
done,
construction,
they
my
have
lords.
done for foundation, immediately I filed this application. After hearing both parties,
I'm invested.
See,
My property, they don't have any document.
see, now that there is a plan, he's also started.
My lord, after filing of the
Wait,
suit, my
wait,
lord,
wait.
yes, ma'am.
He's already started a construction. Let him complete, but not to claim any equity. If
Yes,
he
my lord.
succeed-
I'll
My
give
lord,
an undertaking.
my lord,
I'll give
please,
an
my lord.
undertaking, my
And
lord.
a time may be given, I will file, come up with all documents, my lord, please, my lord.
Otherwise, you deposit that loss which will cost to him if it is not successful.
Yes, my lord, I agree, my lord.
What will be the cost of that construction and all?
My lords, at present it is around 15 lakhs, my lords. At
You-
present.
No, my lord.
At present,
Let
yes,
us,
my lords.
let
I
us,
would
commissioner,
judge foundation, my lord.
inspect, my lord, whatever.
Admittedly, this is the construction he's doing.
No, my lord, it's not, just the gate.
This is
Foundation.
not the photographs, correct photographs.
My lord, I will show, I have produced at the time of filing the application, I have produced a photograph before the trial court, it's there on the record, my
No,
lord.
that is different. Now that he started the construction,
My lord, he
No,
just,
the Supreme Court repeatedly said, if there is any construction permitted to construct, but you should not claim any equity.
my lord,
Now,
and in fact,
suppose
my lord, my
if
submission
it
is,
is
my
in a
lord.
vacant land, then I could have
My
said.
lord, it
Now
is a
that it is-
vacant land, my lord, just to show in the photograph, my lord, he has made some progress, my lord, just he dug a land for foundation. I produced photographs. My lord, it's a photographs I produced already before the trial, but I'm sure, my lord, I have not brought it.
My lord, these documents were produced before the trial court. I have not produced any fresh documents in this appeal.
I will show, my lord.
All the documents were
He
produced
has
before the
produced
trial court.
only pick and choose documents, my lord. I will show all the records, my lord. Fairly I will submit before the court.
Have it on.
My lord.
25th, wait
The
for
number of documents, my lord.
Wait for 25th. We'll have
Yes,
it
my
on-
lord. I will produce all documents. my lord.
Produce, we'll decide. Is this matter? What is the topic subsection?
Lord, so with regard to the address and service of,
You comply in
I'll
the
come.
meantime.
I'll complete.
Leave this matter on 25th. In the meantime, appellant is directed to comply the topic subsection.
Much obliged.
Serial number 15 again, serial number 16, and so appellant.
Appellate plaintiff man.
Yes.
Office objection is that
Regarding that, right, that dependent number 3 to 9, trial court. Yes, what is that?
page number 52, my lord. I have sought relief only against dependent number 1 and 2.
No, where is the plaint?
Right, my lord will get it at page number. My lord, at page number 25.
25. You are the plaintiff or a defendant?
I am the plaintiff, my lord.
Plaintiff. Who is that defendant number?
Now dependent number 1 and 2. 1 is my sister and
No.
2 is my brother-in-law.
3 to 9.
3 to 9 other sisters.
3 to 9. What is that you are challenging here?
My lord, suit is for a partition, comprehensive suit for partition and other declaration also. Because my sister and brother-in-law, when my younger brother he passed away.
No, no. What is that you are challenging? First, we'll.
Now
see that-
come to the page number 52, my lord, where I have sought under R39 rule 10
For what? 39.
deposit of rentals during the pendency of this suit for final
Who are
adjudication.
there in that position?
My lord, position is as it is tenants.
No, that who is collecting that rent?
The first dependent, second dependent, and a fraudulent document of a will.
They are also your family members.
Number 1 is my sister. Number 2 is my brother-in-law. He is a real estate agent.
Where is your IA?
That's the page number 52, my lord. Annexure B. My lord,
Interim order, dependent number
1 and 2.
Yes. Submission of learned counsel for, again, an office objection. Huh?
That's the only one of his objection.
Yes. Submission of learned counsel for the appellant in respect of office objection is accepted. Office objection is told. Yes, what is that matter?
Now on merit, my lord, now as it is in page number 52, I have given details of the amount which he is receiving from the tenant. Because my younger brother, who was fallen to the habit of this is a drunkard and taking advantage
Now
of.
you, come to that page 25, we explain that relationship, how they are related. Page 25.
I explained it, my lord. Now
Now, what is the relationship between the plaintiff and dependent number 1 to 3, 1 to nine? Page 25.
25 page, my lord. So far as relationship is concerned, may I kindly take my lord to the para 3 in 27.
Yes.
One L. Chinnappa, the propositor in the family, a permanent resident of GM Pal, married to Ramaka. Out of this wedlock, 8 children are born. For the sake of brevity, genealogical tree of the family is here produced. Document number 1. The said Chinnappa during his lifetime several landed properties in the village GM Pal. The properties.
I'll explain genealogical tree ಅಂತ
Not
ಹೇಳಿದ್ದಾರೆ.
tree and produce multiple. I can produce it now.
No, you just tell me that relationship.
He is my one sister. And the second respondent is my brother-in-law. And the third respondent in the plaint,
No, that brother-in-law means first defendant.
Married to the first dependent.
First defendant.
Yes,
They are that husband and wife.
Yes, they are husband, my brother-in-law. And this, the third dependent is my brother's son, Chandrapa, he is also no more. And the fourth is again, my brother's son, Chandrani is no more. And fifth is Shanta, my one
Now
of my,
that property is in the hands of your sister.
no, there are several properties where one
No,
of, in my,
rented properties is in the hands of that.
not in the hands of sister, my younger brother, one GC Shekhar, who passed away in the 2019, who suffered ill health due to his habits. At the time of death, he was under my control and I was taken care of. Finally, in the Manipal hospital, he passed away. Then afterwards, when we sat for settlement of the properties which we have given to my younger brother, my sister and my brother came with a will. When he suffered severe ill health, when he had undergone this operation in the hospital, during that period, he got the 1 or 2 documents. Those documents are the, he got it by playing a fraud on my younger brother. That is also under challenge. And overall, my younger brother is unmarried. Now, we are the only legalized, it's a portable estate. After his death, it has to be divided amongst all my brothers and sisters. Now, by virtue of this fraudulent will and gift deed, they are making a claim that we are the absolute owner and they are collecting these rents.
Yes.
So,
Take notice.
I will take notice, Malak.
Yes. Issue emergent notice. Submission of learned counsel for. Yes.
Number 17, Jamil Pasha, appellant.
Lord, I appeal for the appellant. Yes, office objection is not, the IA is to be stitched separately. And Lord, the valuation is to be mentioned. But I will do it right away.
Valuation of the appeal to be stated for the.
Please, I will mention it right.
Number 18, number 19, Sagar taking for appellant, here Vijay Kumar.
Yes, what is
In the last statement, your lordships had directly registered to secure the lower court records.
Yes. We'll post after vacation for hearing.
Yes, ma'am.
This is what that.
Some service of summons to the defendants held sufficient before the trial court. In spite of that, final decree proceedings passed, the execution is pending.
Order 9
They
rule 13
filed
application.
miscellaneous petition.
Time.
9 rule 13, it was also contested after 4 years. They
Yes,
filed.
I can remember that.
Yes,
You want to see
service
that
of-
order sheet.
Yes, yes.
Now that only finally disposed of.
Yes.
And then only 2 days of vacation. After vacation, we'll
Yes,
have it.
your lordship may fix the date at least
Yes,
because the
yes.
execution proceeding stalled.
And third.
Yes.
Yes. This
Interim order may kindly be extended.
interim order granted earlier, if any is extended till next date.
Because 4 years proceedings now.
No, will, anyhow, this is my roster after vacation also. Therefore, I am fixing that. Yes.
Number 20, Vijay Kumar for appellant, connected matter, let's go.
What is this, Mr.?
Lord, I have filed suit before the learned trial court. Suit for declaration to declare that suit scheduled properties are joint properties of plaintiff and defendant. Admittedly, my lord, plaintiff and defendant are husband and wife. I have, my lord, asked the 50% of property which I have earned in my life. My humble submission before this honorable court, accordingly, during the time of filing the suit, I have filed, my lord, IA, that is IA number 7, which is in MFA. Order 39 rule 1 and 10 to deposit the rent before the court. Your lordship may kindly see the impugned order in the MFA. Running by number 13.
Yes.
Which has been filed by the plaintiff before the learned trial court. The plaintiff has filed an application under section 151, read which order 39 rule 10 of CPC seeking direction to the defendant to deposit the rent being accrued and received from the tenants situated under Schedule B and Schedule G and Schedule H property. After the my lord return statement, then my lord issues the
Director deposit 50% of the
Yes.
rental.
exactly my
Now
lord.
what has happened here?
Then it has my lord, one more application they have filed, my lord, that is in CRP 7 rule 11A.
That is also connected.
Yes, my lord, that is connected. They have filed saying that the suit is not maintainable. Their application came to be rejected. Accordingly, they preferred CRP.
After that, my lord, this honorable court connected both the matter, referred to the private mediator, that is Prashant Chandra. I have exercised a lot with the, my lord, my client. We rushed to his office. Repeatedly, my lord, the opportunity has provided. However, my lord, fruitful result has not came. Then, my lord, defendant wife has changed their advocate because of, my lord, that is internal issues. Then, my lord, I have moved before this honorable court to vacate the interim application with respect to the, my lord, vacating of stay. He has filed an application before this honorable court to sell one of the scheduled property. That is also, my lord, 3 days back he has filed, my lord.
Here too for allowing that appellant to dispose of the suit scheduled
Property.
Well, how can he be?
Yes, my lord. My lord, there is a absolute interim order with respect to interim injunction not to sell any of the property before the learned trial court until the, my lord, final verdict of the.
No, that in CRP, what is that? This thing suit further proceedings has been stayed.
Stayed. My humble submission before this.
Who is that? Rajesh Kalapa.
Rajesh Kalapa is the NOC Wakalat who has filed, my lord, and last time, 2 times he has came. He has came through VC. He has came through VC, my lord.
Yes.
My humble submission before this honorable court now is to suit is stalled from last 1 year. I am unable to, my lord, do my evidence. If I am permitted to lead my evidence, my lord, I can see further some achievement before the court, my lord, because my client is, my lord, aged about 74 years, senior citizen, my lord, he is NRI of USA. So that, my lord, if my lord is permitted, I can pursue my suit before the trial court.
No, if he has not come, then we will vacate.
Yes, sir. Please.
Oh, he sought for rejection on what ground?
Rejection of 7 rule 11, there is no cause of action to the suit. Your lordship may kindly see the, my lord, CRP order, wherein, my lord, order on IA, that is impugned order is X, page number 7, on order IA number 26, my lord.
Give one more chance, we will record that he is absent today.
My lord, my humble submission, my lord. Now, from last, my lord, 1 year, I am waiting for to lead my evidence. If he is, my lord, the plaintiff is present before this honorable court, aged about 74 years, he is a NRI, my lord. He is. I may permitted to pursue my case before the learned trial court.
No,
that
can be done by allowing your application.
Otherwise, my lord, the suit is, my lord, went to the cold storage. That is the biggest problem.
No, he is not there. What to do? Pass over.
I will wait, my lord. I will wait.
If you know, ask him to present.
I will request him, my lord. I will
Otherwise, court is going to.
Definitely, I will request him, my lord. Kindly call by 2:30, lord. Please,
Pass over.
please.
Yes.
You know, these are those, you know, their cases. Common judgment was passed, they filed 40 appeals.
Yes.
So,
Same order.
but yes, Milord, I'm just.
All matters.
Yes, Milord, I have just one thing, Milord, in section, this serial number 21, execution case has not been filed. So I request your lordship to permit me to deposit amount here. Other cases we are depositing in execution. But here
No,
says
that
there is
40% award amount before the reference court within the week. Reference court, they said, not executing court. They said
so
reference
in
court.
LAC we will.
LAC. Reference court is the.
Otherwise, Milord, this matter is pending here, so we thought LAC is closed, so
All others, they have filed an execution.
yes, Milord.
Yes, under Israeli. Number 21 ali.
21 and 24.
Huh?
21 and 24.
21 and 24 ali.
Yes.
The order expressed in view of the above, IA is allowed. There shall be an interim order stay of execution in so and so. Subject to the appellant deposit 40% of the award amount before reference court in today. Elderly before this court. Within 6 weeks from date of receipt of copy.
20.
Within 6 weeks from today.
Yes. From receipt of certified.
Huh?
From receipt of certified.
Why?
Please, Your Lordship.
No, in all that it has been
Yes,
done by
please,
receipt of copy of this order.
Please, Milord, and
But
then,
it should be from today.
yes, and those Milord, other IA Milord to dispense with production of certified, Milord,
All
similar,
that
exactly
will-
same Milord,
Same.
same. Now,
One day one though, serial number 21 and
21 and 24. Milord.
24. Elderly 40% has to be deposited before this court. In Bakidrilla before the reference court.
Yes, Milord.
Now, my lord, one case, my lord, serial number 26. My lord, order was passed earlier, my lord, on 6/10, my lord. Order was passed, and then we realized, my lord, there is no execution. So there, my lord, that clarification is required.
26.
Serial number 26, yes, my lord. Lord, I mean, memo I'm producing in each metric required, my lord.
26 ಅಲ್ಲಿ IA ಇಲ್ಲಲ್ಲ? You are filing memo.
Yes, my lord. My lord, only, my lord, that clarification that this court, my lord.
No, that is
Instead of
true. Have you filed any application or any?
No, my lord, only a memo has been filed.
Memo file.
Yes.
Memo post ಆಗಿಲ್ವಾ? Post ಆಗಿದೆ. Notice to. No, first time ಬರ್ತಾ ಇದ್ದಂಗಿದೆ.
My lord, no, my lord, interim order granted, but that time, my lord, it was directed to.
You file a memo. This is MFA 2782 of 2023. Memo file is there. Senate Council for Appellant have filed a memo seeking clarification of order dated 6/10/2023 passed on IA number 3 of 2023. The memo is taken on record. Updated 2023. There is a direction to deposit 40% of the award amount before the reference court is modified. Directed to deposit before this court within 6 weeks from today. Yes. To that effect, order dated so and so modified. IA4 for what? Dispensation. Today it is posted, Allah. IA4 of 2023 is allowed. Order dated so and so. Production of is dispensed. Now that you have to pay the process, we have issued an yes. In the Karnataka Council for Appellant submits that needful the process has been paid. Office to verify and issue notice to respondent. Delay and notice. Delay notice. Yes. We are issuing the notice and staying that order. Yes.
31, release for appellate.
Yes. One for permission to prosecute for additional documents. What is this, Mr. Who are you? Your name is there in that this thing. Notification. What is that miscellaneous, civil miscellaneous? What is that land acquisition officer has passed an order? How much amount has been awarded? Adhan reference ಮಾಡಿದ್ರ ಅವರು? What is that order you are challenging, Mr.? No, what is this order passed by that additional district judge? Yeah, some land acquisition act. This one. Payment of compensation deposit in claim. Payment of compensation. They have filed an application. You have filed any objection there before that? What is your name? Who is Krishnappa? Who is- Hmm. Why you have not been made as a party there? ಏನ್ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಏನು ಆರ್ಡರ್ ಮಾಡಿಲ್ವಾ? ಎಲ್ಲಿ? The entire amount. Then you are not why you are not included there? But notice. Yeah. Dated 1st August 2023. Past 9. First Additional District Judge. Tumkur. With miscellaneous number 1 of 2022. Hearing. Yes. Not. This. No, there is a delay. Yes, notice has to go.
But I took for that one. Notice on IA as well as on main make.
Yes, both issue notice. Yes, one time.
Your Lordships, I am appearing for the petitioner, Your Lordships.
Yes.
My apologies for not appearing in person, Your Lordships.
No, that he wants time to file an objection.
Your Lordships, warrant has already been issued against the petitioner. That's the issue, Your Lordship. Warrant has been issued against him. If I may bring it.
What is this matter, Mr.?
Your Lordship, petitioner and respondent are husband and wife. Now the petitioner has been directed to pay a certain sum of money as maintenance. The issue is that on 20, if I may bring your Lordship's attention to page number 58 and 59 of the petition.
Yes.
In page number 58 and 59, the respondent has filed a complaint, Your Lordship, stating that she has been living with another man from 2001. Since 2001, she has been living with another man, and she says that she's even taken divorce from this from the petitioner.
No, but by saying itself is not in a divorce unless it is obtained by due course of law.
And Your Lordship, she admits herself that she's been living as a wife with another person. If I may read, page number 59. Page number 59, Your Lordship.
Already 13B petition is filed. The matter is settled. And yes, 13B petition is filed, Manap. They have agreed to settle the matter by paying the 4 lakhs. In that 50,000 they have paid. Remaining 3,50,000.
Yes, Mr. Your client has settled that matter.
The first petition company first is
In that case, Your Lordship, with respect to the execution case, with respect to warrant, maybe stayed, Your
How you
Lordship.
can't execute?
Well,
in that case, let them not execute, Your
They are
Lordship.
not paying any amount in the before the court, Malad. Only that amount, if they have paid, the matter will be closed, Malad.
ಈಗ ಇದು ಕಾಂಪ್ರಮೈಸ್ ಸೆಟ್ಲ್ ಆಗಿದೆಯಲ್ಲ,
ಹೌದಾ?
ಇದ್ರ ಮೇಲ್ಗಡೆ ನಾವು ಯು ಹ್ಯಾವ್ ಟು ಎಕ್ಸಿಕ್ಯೂಟ್.
ಈ ಸೆಟ್ಲ್ ಆಗಿರೋದು 13B ಅಲ್ಲಿ ಪೇ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ 13B?
ಅಲ್ಲ ಫಸ್ಟ್ ಇದ್ರಲ್ಲ
ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲ 13P ಅಲ್ಲೇ ಅದ್ರಲ್ಲೇ ಒಳಗಡೆ ಹೇಳಿದಾರೆ. 3ನೇ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳಿದ್ರು. ಈಗ ಅಮೌಂಟ್ ಹೇಳ್ತಾ ಬರ್ತಾರೆ 4 ಲಕ್ಷದಲ್ಲಿ 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
Petitioner submitted that first petitioner has filed a serious petition before the petition honorable court has ordered to the 6th per month. ಯಾವ್ದ್ರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಹಾಕಿರೋದು ನೀವು?
ಈಗ ಅದೇ ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಸಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ. ಅಮೌಂಟ್ 4 ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋ ಅಮೌಂಟ್ ಅಲ್ಲಿ 50,000 ಕೊಟ್ಟಿದ್ದೀವಿ.
4 lakhs.
Out of 4 lakhs ಅಲ್ಲಿ 3,50,000.
50 by way of cash, the petitioner has agreed to pay remaining amount of 3 lakhs.
50,000
time of evidence.
ಎವಿಡೆನ್ಸ್ 13P ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಕ್ ಕೊಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಈಗೇನಾಗಿದೆ ಅಲ್ಲಿ 13P?
ಈಗ 13P ಪ್ರೊಸೀಡ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಐ ಆಮ್ ರೆಡಿ ಟು.
Yes, Mr. You have settled, you pay that amount.
Your
One
lordship,
breath you are saying that yes, I
yes,
will
yes,
pay.
they were in talks to settle, your lordship. In the meantime, she files a complaint against one Mr. Krishna, saying that she's been living with him as a wife.
Rightly or wrongly, then you have agreed. You are not ready to pay that amount, then pay that maintenance.
Your
Either you
lordship,
have-
we will pay whatever that needs to be paid, but until then, warrant may be stayed, your lordship. The warrant
No,
has
that
been
we are-
issued against.
No, when will you pay that 3,50,000?
Your lordship, she's been in adulterous relationship with one Krishna, your lordship.
No.
I'll only take 1 minute of your lordship's time. Page number 59, your
Mr.
lordship.
You have to take one stand, whether you want to pay that as per the settlement or you don't want to pay.
Your lordship, we are not going ahead with the stay. We are not going ahead with the 13B petition because she's not been our wife. That is the issue, your lordship.
ಆಯ್ತ್ರಿ, ಮತ್ತೆ ಅಲ್ಲೇ ಯಾಕೆ ಮತ್ತೆ 5 ಲಕ್ಷ ಕೊಡ್ತೀನಿ 4 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದೀರಿ?
Initially, this was not brought to the light. This issue was not brought to the light. The fact that she was in an adulterous life was not brought to light, your lordship.
Court will decide
Recently, we
after
came
that,
to
right?
know that a complaint has been filed.
No, it has to be decided before the court. Is it not? Till then you have to
Yes,
maintain
yes, certainly, your lordship. Until then, let there be a stay of warrant, your lordship.
You pay 50%. 3,000. Yes. Yes. But there is a delay of 409 days in filing an appeal. Here 1 of 2023 is filed for condonation of delay. There is that affidavit for the reason stated in the accompanying affidavit. Delay of 409 days in filing an appeal is a petition is condoned. IA 1 of 2023 is allowed. But the learned counsel for the parties on IA 2 of 2023, stay of order dated 31st day August 2021 passed by Family Court Mysore in criminal miscellaneous 687 of 2011, subject to condition. The petitioner is directed to pay 50% of the arrears of maintenance within 8 weeks from today. And he is
4 weeks,
directed-
your lordship.
Huh?
4
12
weeks,
weeks.
4 weeks.
4 weeks.
I said 8, you want 4 weeks.
8 weeks is fine, your lordship. My apologies. I heard it as 3 weeks.
Yes, 8 weeks. And he is directed to pay monthly maintenance 3,000 per month. Hereinafter. Yes.
Your lordship, subject to result of the petition, because we are disputing their marriage itself, your lordship, subject to.
No, till divorce, you have to maintain your wife, is it not? Anyhow, you pay that 3,000, let us, yes.
Yes, your lordship.
Number 35, Syed Kamruddin for petitioner, M. Manjunath.
Getting entry matter, you are appearing for the petitioner. Where is that other side? Yes, is this matter of none appear for the respondent? Is this matter of 2 weeks? Matter granted earlier, if any, is extended till next date of hearing.
This is submission. Let me make a submission. The respondents are the plaintiffs. Filed a suit for
No, that is his case. Let him argue.
No, no,
After
no.
that, if you want time, then only you can.
If it is to be for admission, no problem. Why I filed an application for temporary injunction because the construction vector moved in that.
How can you file here?
There is a stay in this before this court, staying the further proceedings in the suit. They stayed meanwhile that.
You file it in that counter.
Comment.
You file it in that counter, Mr. It has to be numbered and it has to be posted before the court.
Photo, just only photographs and
That you-
application has been already filed. Is waiting.
Yes. Is this matter on
My lord, there is a point. If it is interim order has to be considered, otherwise, it is just see the photograph.
No, for you file it in that counter, Mr. It is not in a this thing. You are handing over everything here. After serving that, you file it there. We'll have it on 25th.
My lord, otherwise, just see, my lord, it is, building will be completed, it's suit for injunction, the suit will become infractions. The whole proceedings. Plaintiff, suit for permanent injunction, subsequently it was a trespass.
Yes. What is this suit, Mr.? What is that interim order? They have further proceedings. Then you file an application for vacating that interim order.
From meanwhile, they are putting up a construction, unauthorized construction.
See, you want to seek any injunction, you have to file in a separate suit. Not in this application he has filed. Now that his application is coming in your way, interim order, then you have to file an application for vacating this interim order. Then we vacate, you file before the original suit. Now that you have, only thing is that coming in your way is that interim order. You file an application for vacating, we will hear.
Because I cannot file an interim application before because of.
No, that's what, therefore, now you have to file an application here. In view of that,
I filed this.
no, you have filed an application for injunction. How can it be filed? In his petition, you have to file an application for vacating. You file an application for vacating, then we, if the interim order is vacated, then you can file an application for injunction in the suit.
By that time, status quo will be maintained till that next date of hearing. Otherwise.
You file an application. You file an application.
I'll make an application.
This
Let it be listed tomorrow. I'll file it.
Serve it and post it on 25th reopening day.
Otherwise, otherwise this the entire building will be completed.
No, anything it's subject to the result, Mr. If it is tomorrow, if you succeed, you will get back everything. Whatever Supreme Court said, if there is any construction, proceed. But all is subject to the result. Yes.
Because where injunction suit here, it's not a title suit. If the building is trespassed and constructed, if it is not stayed, then it will be the suit will be infracted before the trial.
This matter on 25th. Yes. In the meantime, you file an application. Yes. Interim order granted earlier is extended till next date of hearing.
Your lordship may kindly be permit you to move it before the vacation.
Yes. The learned counsel for the respondent raise urgency in this matter is permitted to move. Liberty is reserved to move before the vacation bench. Yes. Interim order granted earlier is extended till next date of hearing. Yes. Yes.
Statement of objections.
Yes, what is this matter? We'll have it after vacation. Is this matter? You want any date? 27. Is this matter on 27?
Number 38, agrees connected matter, B. Ramesh.
For the respondent.
Yes. Yes, we'll same have it after vacation. Yes. Any date if you want. 30th.
31st, my lord.
31st. Yes.
Yes.
Use this matter on 31st.
Number 39, Parmeshwar Parsi for petitioner, Jyoti SK.
Matter has to be heard finally. Then we'll have it up to vacation. But in the 2022, from 22, we have no interim order. Yes, we'll have it on 25th. Yes. Use this matter on 25th.
Number 40, Nandish Patil for petitioner, absent but.
My lord, the respondent number 1 minute.
Yes.
My lord, in this matter, my lord, on the last occasion, my lord, your lordships had directed us, my lord. My lord, am I audible, my lord?
Yes, yes, yes.
My lord, on the last occasion, my lord, your lordships had directed us to file an application under Order 7, Rule 11 and pursue the same.
What is this then?
My lord, now
When there is an application under section 11 of the
an application.
that it is a, there is a res judicata. One of the defendant had filed an application.
We'll have it after vacation. Yes.
Please.
My lord, my humble submission is, my lord, the matter could be disposed of with a direction to the trial court because I have filed an application under Order 7, Rule 11. Let the trial court consider my application, my lord.
Yes, we'll dispose of. He said that.
Disposed of with that direction, my lord. Because, my lord, the whole.
What is this order you are challenging here?
Please, my lord, the order, my lord, we had made my lord, what had happened, my lord, there is one suit, my lord, that is numbered 48/2014. Please, my lord, this suit, my lord, it's a suit for partition, my lord, which was filed amongst the brothers.
Yes.
My lord, that suit, my lord, came to be dismissed.
Yes.
My lord, one of the other brother, my lord, who was a defendant in the earlier suit, who had admitted, my lord, that the properties are not ancestral in nature, and my lord, the properties are self-acquired properties, filed another suit, my lord, with the same relief. My lord, we at that instant, we made an application.
Yes, now we will dispose of this, dismiss this petition with direction to consider your application.
Please, my lord. Now, my lord, as per lordship's direction on the last occasion, my lord, I have filed an application under Order 7, Rule 11 for dismissal of the suit. Let that be considered in accordance with law, my lord.
Yes, please. Yes. This petition is filed by defendant number 2, section 115 of CPC, alleging order dated 23rd 2022 na 2022 whereby trial court has dismissed that IA filed by defendant number 2 under orders under section 11 of CPC.
Please.
Sake of convenience, but for the ranking before the trial court, the plaintiff has filed a suit for partition and separate position. On service of summons, defendant appear through their counsel. Defendant number 2 has filed application under Order 11 of CPC under section 11 of dismissing the suit. Trial court by order dated 23rd 8 2022, the application being agreed by the same. The defendant number 2 has filed this petition. During the pendency of this petition, defendant number 2 has filed application under Order 7 Rule 11 before the trial court, seeking for rejection of the plaint. The counsel for the appellant, the petitioner, defendant number 2, submitted that this matter may be disposed of with a direction to the trial court to consider that application filed under Order 7 Rule 11 of.
Please.
In view of the above, the petition is The civil revision petition is disposed of, directing the trial court to dispose of the application filed by the defendant number 2 under order 7 to 11 in accordance with law. Yes.
I'm obliged.
All pending applications are disposed.
I'm obliged.
Yes. Yes. Where is your opponent? Who is your opponent? Where is that execution? Yes. The counsel for petition submits that. The respondent herein has filed an execution petition in execution number 1184 2023 before the before the small class court and appear for the respondent. Till next date of hearing. The proceedings in execution petition number so and so. Yes.
Number 42, for appellant.
I'll not precipitate. I will give this undertaking before.
Lordship, I kindly stay that proceeding.
I will not precipitate.
Submit ಮಾಡಿದ್ರು Lordship call for the record.
I will not precipitate. My lord, kindly have this matter on 26th or
No,
27th.
your Lordship, I kindly stay the proceedings.
Stay ಏನು ಬರ್ತದೆ?
How to execute ಮಾಡ್ಬಿಟ್ರೆ how to believe it?
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಲ್ಲ ಓಪನ್
ಇಲ್ಲ ಅವಳು ಓಪನ್ ಕೋರ್ಟ್ ಹೇಳಿದ್ರು last
No,
time.
no.
He made the submission on 19/6 before your Lordship on 4/7 and he did
Yes.
find the
Yes, release this matter on 27th.
Your Lordship is stay the.
Council is making.
No, we can't. Nale,
You can't believe. Mister, you can't believe. I will believe. I will grant.
ನಾಳೆ order ಮಾಡ್ಬಿಡಿ record ಅಲ್ಲಿ ಇದೆ.
No, I will reject your entry mod.
ಇಲ್ಲ no they have not done it.
No, if you argue, I will hear and reject that.
ತಾವು one request your
In
honor.
the first case, council was not present. Therefore, I can't believe that whether he may prosecute. He is saying that he will not prosecute.
Yes, maybe recorded.
Yes.
That may be recorded.
Yes. You are not believing that your colleagues.
Believing
Yes.
we have to believe but trustworthiness.
Yes. Learned counsel for respondent Aviator has undertook that he will not precipitate that execution petition till next date of hearing. Use this matter on. No, the reason is you are a tenant or a landlord.
Without
That is
paying,
the
there
reason.
is more than
One
10
second
years.
is granted.
First week of November.
More than 10 years.
I am going out of station first week of second or third.
ಇಲ್ಲ 27ನೇ ತಾರೀಕು ಹಾಕೊಳ್ಳಿ.
ಇಲ್ಲ second I will not be in station. Second or third.
Yes, on second.
Second.
Yes.
With your Lordship can serial number 2.
Wait. Yes.
Kindly.
You want time? I will
ಇಲ್ಲ
urgent.
execution ಹಾಕಿದ್ದಾರೆ. I am receiving call.
No, I am in that list. If you want time, I will urgent.
No.
There is no such special.
will
Wait till that your turn has to come.
Idea.
Yes.
Yes.
My lord, the trial court would proceed to allow an application under order 12 rule 6. In the first instance, the application is dismissed because the suit filed by the plaintiff against the defendant for an ejectment. My lord, kindly take page 43 of the plaint. 43, my lord, that is the plaint. The plaint seeks a number of reliefs. My lord, when the application is filed, kindly see the plaint, my lord, at page 43.
Yes, now what is that?
Now the order is not first an application. Before I file the written statement, an application is filed under order 12 rule 6, telling that I have admitted the relationship, therefore pass a decree the suit insofar as possession is concerned. That is dismissed. After I file the written statement, an application is filed to review the said order. And in that review, the court passes the order. Kindly see the impugned order now, my lord. Page 35.
Yes, now that suit is decreed.
Suit is decreed only in respect of possession. The other aspects, other reliefs is pending. There cannot be two decrees in this.
How that they are possible? Yes.
And now, my lord, execution is filed.
Yes.
In execution number 1295 of 2023.
Stay up for the proceedings in execution number
1295 of 2023 SCCH 04.
Yes. Before the small class court till next date of appeal. Yes. Notice.
Over.
Yes.
Yes.
Notice or not. Till next date of yes.
For some time. Maybe for yesterday. For consideration of interim prayer, it has come, Lord. Now the event is.
Why it is urgent?
Because it was heard in for appreciation for purpose of attack. But thereafter, your lordship also wanted to know what purpose the gate is posted. What has happened to the trial court is an application for temporary injunction has been heard by the court already.
No, you just give that brief facts. I forgot.
Yes,
My lord, this is, my lord, your lordship may kindly take, my lord, the memo filed, my lord.
No, there's a suit for.
My lord, this suit is filed, my lord, for seeking, challenging the appointment of trustees, my lord, indirectly with the prayer, my lord, saying they shall not function, my lord, at page 31.
Yes.
Lord, for a declaration that the defendant number 1 and 2 are not lawfully appointed trustees of the plaintiff 1 Bandaram in accordance with the trust deed dated 8/10/1923 and consequential prohibitory injunction restraining the defendant number 1 and 2 from committing, executing any acts, deeds, things purporting under as trustees. Prohibitory injunction restraining
Not lawfully appoint the trustees of the plaintiff.
So the essentially suit is not challenging the appointment of trustees and not to appoint the further trustees. Lord, after filing the written statement, we have filed Auto 7 Rule 11 application saying this suit is not maintainable for the reason that, my lord, the suit is barred under section 92 of CPC, where this is a public trust and the section 92 is applicable.
Yes, after that, I gone through that provision and I have mentioned today what.
Now, for consideration of interim order only, my lord. Your lordship was about to pass interim order. Then, my lord, my learned friend, my lord, canvassed about the other pending matters, my lord. Lord, there are 3-4 other matters pending. Lord, what happened is, my lord, in the year 1994, the plaintiff number 2 was removed from the trust. That was challenged, my lord, in a suit. Yes. And that suit, my lord, now has been dismissed and now the RA also dismissed. He is in RSC. There is no interim order. As of now, my lord, he don't have locus to represent the very trust. He says he claims to be a managing trustee, my lord. Since he was removed, he don't have locus to represent the trust. Lord, now and he has suppressed the material fact. Lord, we have filed one memo for production of document where it has been held by this honorable court in RSA number 3. Lord, at page 1, your lordship may kindly take, my lord, the memo where page 1, along with the memo we produced. The very same issue was adjudicated, my lord, before this honorable court in RSA 1573, yes. Along with the memo. Page 1L. 1L, my lord, this respondent number 1 is plaintiff number 2 in the present suit.
Yes.
My lord, the respondent number 2 is the defendant number 3 in the suit.
Yes.
My lord, both are parties before this honorable court, my lord. Now, your lordship may kindly come to, my lord, page 3, where the defendants having entered appearance had raised the plea that the suit was barred under section 92 of CPC. An issue was framed
as to whether the suit was maintainable and the same has been held negative and on the ground that trust was a public trust. This having been affirmed by the first appellate court, this appeal between the same parties, my lord, whether plaintiff or defendant, my lord, it is inconsequential.
No, what is that issue there in that?
There, my lord, the very same, my lord, his brother, now the plaintiff number 2's brother challenged, my lord, the appointment of trustees in a suit.
Appointment of trustees.
Trustees, new trustees.
Where is that plaint? You have the plaint copy?
That plaint we have not produced, my lord. This is,
Where
my
is
lord,
that any reference?
My submissions.
my lord, thereafter, my lord, kindly now, your lordship, my only endeavor is this, my lord. Already there is a finding by this honorable court that this trust is a public trust and 92 suit can only be filed if anybody has got any grievance. Kindly see, my lord, para 4 at page 5.
No, that 92 only in that proviso.
Yes, that
What are
No,
the
proviso, it is there, my lord. I will read out the proviso for you.
No, therefore, I
Yes.
want to see whether similar relief is claimed in this suit also in RSA, which we are relying. What is the plaint? Somewhere is there any extracted that relief claimed in that plaint? I
Your
want
what-
to see whether there also is challenging that appointment or is removed.
I'll read out the order, my lord, relevant portions. Lord, the next, my lord, the learned counsel for the appellant would submit that the trust was clearly a private trust meant from benefit of the community membership of which we ascertained at any given time, and therefore the firstly it could be held that there was no bar under section 92 of C. Even it is where so be. The trial court having failed to frame an issue in this regard, the appellant never had an opportunity to tender evidence to establish the trust in question was a private trust and not a public trust. If it is to be held in favor of the appellant, a substantial question of law would arise that whether the trial court was justified in dismissing the suit on the ground that is barred under 92 for want of the leave of the court and other requirements. The council would also point out that the appointment of respondent number 4 and 5, this is the issue. Appointment of respondent number 4 and 5 is clearly in breach of the trust deed, and the trial court was therefore in error in rejecting the suit on the preliminary objection as to the maintainability. Having heard the counsel at length and the decision cited in Hirendranath Bhattacharya, it is seen that trust in question was for the benefit of Gauda Saraswata Brahmin community, which would imply that it is for the benefit of fluctuating body of persons and no fixed group of persons could be identified as beneficiaries, in which event it cannot be said that the trust was a private trust. This is a fact that is apparent without any elaborate evidence in this regard. The defendants having raised a plea that there was a bar under section 92 and the trial court having framed an issue as to maintainability and having answered the issue in negative on the footing that the suit was not compliance with section 92 and therefore was not maintainable, cannot be said to be irregular or illegal. There is no question of law that arises for consideration. The judgment and decree having been affirmed by the first appellate court, the finding of the fact, therefore concurrent finding and does not warrant interference by this court. The appellant, however, is not without remedy in that the appellant would be precluded from filing a suit on the basis of the trust is a public trust and bringing proceedings in accordance with law. Now, liberty has been reserved, my lord, to the appellant therein to file a 92 suit. This is undisputed fact, my lord, that the trust is a public trust. This is the categorical finding by this honorable court. Now, appointment was under challenge, my lord. This page 4 I read out, my lord. Yes. Therefore, my lord, this is the finding attained. Is final, it has reached the finality. Now, the present suit has been filed, my lord, which is clearly falls within the scope of section 92. But may I read 92, my lord? Yes. Lord, in the case of any alleged breach of any express or constructive trust created for public purposes of a charitable or religious nature, or wherein a direction of the court is deemed to be necessary for the administration of any such trust, Advocate General or two or more persons having an interest in the trust and having obtained the leave of the court may institute a suit where contentious or not The
Yes,
principals
it
will.
appears to be there also appointment of respondent.
Contemplated in section 92 CPC is there. It must be a seeking for removal of any trust.
Yes.
Or seeking for appointment of a trust. These are the situations. Here is a case, kindly see the plaint, Your Lordship. Here is a case where we are not asking for removal of a trust. Our contention is very appointment is illegal. In such a scenario,
Trustees only.
is correct. In such a scenario, if the
Cleverly drafted plaint.
no, it's not, let me complete.
Yes, let him.
I did not interrupt.
Yes.
But there is a judgment of the Madras High Court considering exactly similar situation. 1957, 70 Law Weekly, page 960, 96. The head note here.
Yes.
Sued for a declaration that the person is not entitled to be a trustee, whether falls within the section removal scope of court's jurisdiction. A suit for a declaration that a person in office was not entitled to be a trustee, and that is the assumption of the office itself was invalid. It doesn't fall within the scope of section 92 CPC. The principle should be the same, whether it is a personal right of the plaintiff to be the trustee that is asserted, or whether it is a personal right of one or more of the defendants to be trustees that is denied. Whether when the right to hold in office of the trustee is asserted or denied, the relief is asked for on that basis that would appear to fall outside the scope of section 92. The removal for which section 92 CPC provides cannot be construed to include within its scope cases where the right to hold the office itself is challenged. To put it in other words, a trustee de jure can be removed. A trustee is without any legal right to hold the office. Here is a case where in the plaint, kindly see the plaint. Kindly see the plaint, which has been produced along with the papers. The relief that is sought is Mirror case 31. Yes. For a declaration that the lordship page
Yes.
31 down
Page
below.
31, yes.
For a declaration that defendants 1 and 2 are not lawfully appointed trustees of the first plaintiff, and in accordance with the down below the last sentence, in page 31.
31.
Yes, internal page 15 of the papers. Page 31, in page 31.
Page 31, whether the plaintiff proved that the issues are there.
There's some page mistakes.
Here petition, along with the petition.
Petition only.
Yes.
Running pages of the petition.
Page 31.
31.
Yes, yes.
Para 5. The plaintiffs therefore pray for the judgment and declare the defendants for the following reliefs. For a declaration that the defendants 1 or 2 are not lawfully appointed trustees. We are questioning the very legality of the appointment. No, that's what I said. That's what Madras High Court. The very question relating to the appointment, legality of the appointment is raised. And on that basis, the relief is sought.
No, but the section says appointment of the new trustees.
Appointment of the new trustees and here therefore, the suit should be, I have got a judgment also on that point. So, what section 92 contemplates is a prayer where a suit is filed requesting the court to appoint new trustees. It is not a case where appointment of the trustees is challenged. I read section 92 once again. Kindly read. To obtain a degree, kindly see the last sentence. The section 92 does it.
Yes.
In the case of an alleged breach of any express or conceptual was created for the public person charitable or previous period, or where the direction of the court is deemed necessary for the administration of any such tax, the advocate general or 2 or more persons having an interest in the trust and having obtained the leave of the court may institute a suit, whether contentious or not, in the principle or any other court employed in that behalf by the state government within the local limits of whose jurisdiction the whole or any part of the subject matter. To obtain a degree, that is one. What is the degree? Removing any trustee, asking for removal of the trustee. Then appointing a new trustee, asking for the relief that a new trustee should be appointed.
What is the next date? The suit has been.
It is what has happened.
Tomorrow it is posted for
Orders on
clarifying
injection,
the situation.
temporary injection.
Whether my submission is this, what is it is posted for passing orders on the application for temporary injunction. Applications have been already heard. He has also, the other side also has argued, my client also have argued. We really don't know in which side the application is going to be decided. How can, by getting an order of stay?
That will not come in the way of deciding.
Your lordship may do one thing. They let the order be passed, irrespective of whatever it is. Because they cannot say the guise of fighting is this revision petition. Your lordship may say what happened is this. The revision petition order was passed long back. Thereafter, the application was heard by from both the parties. Application is posted for orders. I'm not saying, I don't know in which side the matter is going to be decided. Now, how can they ask for stay of passing of an order by the court in a petition where the court only contention is question is whether the plaintiff is rejected or not. Finally, if the plaintiff is
Foundation.
that's a different issue. They cannot ask for an interim order, staying the pronouncement of an order by the court.
No, we can grant stay all further proceedings in the.
But what I am submitting is.
That is what we are saying.
This is an indirect way of stalling the pronouncement of the order. Which is not happen.
No, that can be done by this
No,
court.
what I am
That, without any
provided-
jurisdiction, court is exercising.
My submission is whether the court has jurisdiction or not is a matter to be decided by this one. That's one.
No, that is what I am thinking that. Why can't you postpone till that reopening? We'll hear this matter. on the-
Your lordship,
Because what is that
we made one
other,
submission, we had-
what is that other, this thing has been filed?
No, nothing has
Others-
been filed.
No, there are not number of.
No,
matters
other
pending.
aspects, no, I will submit.
Lordship may
There are
kindly see.
second appeal is concerned. That is in a different situation altogether. We will move that matter also before the appropriate. date.
They are not arguing, my lord. From 2008, it has
That's
not
it.
seen the light
What
of the
is
day.
that suit
Simply
for?
they are adjourning it.
Wait. It is not my this thing. Just I want to know
The
that
suit is.
how it is related to this.
Suit, I will submit. That is a suit filed by the plaintiff. Seeking for a declaration that the resolution passed by. Seeking to remove him as illegal. And also inducting certain persons as hangamakas is also illegal. What has happened is, on merits we have succeeded.
No, that what is that injunction you have sought now?
Where we are.
Now that it is ready for pronouncement.
Restraining these people from this one operating. We don't know what is going to happen on the application. We have argued on merits. That is for the trial court to pass an order. My respected submission is this. Your lordship may post it immediately after vacation. We are ready to argue the matter, this matter. And your lordship may
If there is
also.
any adverse order passed, you challenge.
They can always.
That will come in the. My lord,
Neither of the
this-
parties can challenge.
No, but
My
by
lord, just-
reading,
just, my
by
lord.
reading section 92, declaration sought, it is not covered under 92.
Yes, my lord. That's
My
what
lord,
I
that is, that is the clever drafting. My lord, kindly see, my lord, the very same, my lord, coordinate bench.
Two more judgments of this honorable court.
My lord, I'll submit, my lord, on
This
this.
is a division.
But now,
of this honorable
The,
court, which
so
speaks
far as
about
92
how
suit,
section
my
90
lord,
has been interpreted.
the same suit was filed by the brother that was dismissed. And Arya, my lord, I have read over, my lord, how the findings have been
Now-
given. Now
What
the,
is your right to seek for?
yes, my lord, that is
declaration of
very
appointment?
right is not there. He is a stranger now.
No,
He
see,
don't have locus.
You cannot
Suppose,
say so.
no, suppose. See, any persons who are the trustees, they can file it.
I am also.
You have been removed from the
No, no,
trust.
that very question is pending before this court. Apart from that, on merits, both the courts in which they have already held that the resolution that is passed seeking to remove as a trustee is illegal. And inducting of those angamators is also illegal. Suit has been dismissed only on a technical ground that one of the trustees who died, his LRs were not brought on record. That is the point. On merits, I have succeeded. Unfortunately, on technical ground, we have lost.
Lord,
Your lordship may have it
he
immediately.
used to keep on filing suits, my lord. One of the suits, my lord, now at Arya stage, my lord. That judgment, your lordship may kindly read, my lord, page 102 for a moment. Memo, in along with my memo. Lord, this is one of the suit where my lord, his plaint was returned on this ground alone, saying 92 suit has to be filed. And my lord, in that suit also, the very same advocate files suit and he suppresses this material fact that RS has been decided in the against it.
The scope of Article 7 to 11 is by respect to sufficient.
So that
They have not
fact,
stated so.
my lord,
in the
simply
trial
they,
court.
my lord,
Let him complete.
my lord, they
I
say.
am not taking any decision. Why
My
that
lord.
advocates are this thing?
I-
Or they are reading the mind of the court that I am going to pass it.
We can never do so.
Yes,
We are
but
very
then I
tight.
have to hear and pass an order.
My lord, in the.
If both are arguing, then I can't hear.
No, my lord, I will complete, my lord.
Yes.
My lord, in the plaint, they suppress this deliberately, my lord. The aspect of pendency of RA number 151753 of 2007.
Yes.
So that, my lord, the court will not be in a position to say by reading the plaint that the suit is barred under 92. And this, the res judicata aspect also they suppress. Not having suppressed so, my lord, they filed number of suits. In one of the suits, my lord, plaint has been rejected following this RSA. And my lord, that RA has been filed, that has been confirmed, against which RSA they have filed, that is pending. There is no interim order. They simply take time in that RSA also. There are two RSAs pending. Now, my lord, that while dismissing the RA, kindly read the, my lord, findings given by the court at 102. Memo joteg hakiddu. Adralli RA number 11 finding nodebitre. It will be clear. Every time he will file one suit suppressing this material fact. And my lord, there are kindly, my lord, I will pass on a list how many suits he has filed suppressing this material fact. And now page 102. Page 102 of the memo, my lord.
Yes.
But there, page 18, as rightly argued by the learned counsel for the appellant plaintiff, it is tried, which is the para 18.
Yes.
Learned counsel for the appellant that it is tried law that a plaint shall be liable for rejection in cause jurisdiction under 7 rule 11 if it appears the averment made therein the suit is barred by any law in force for the purpose of deciding the application under clauses A and D, rule 11 of the 7 CPC and the averments plaint are germane. The plea taken by the defendant in written statement would be irrelevant. In the present case, this is very important. In the same thing in this case also. The present case, of course, the plaintiff stated in the plaint that the plaintiff is a private trust. Therefore, the contention taken by the defendant in the written statement and affidavit which he filed in support of the application for rejection of plaint that the first plaintiff is a public trust cannot be dealt with while deciding the application under Order 7 Rule 11D of CPC. Nevertheless, it cannot be ignored that the plaintiff, though made a clear reference about several litigation held between the plaintiff and other person, but has cleverly not whispered a sentence about the result of RSA number 1753 of 2007. Same thing in this plaint also.
In this case, we have disclosed.
No, no,
Not
no,
so.
no.
I will read it.
If it is disclosed, then it is clearly barred by res judicata. To elaborate, as could be seen from the plaint government itself, the legislative process was started. The legislative process was started by the plaintiff in the year 97 when he filed a suit in OS number 497 of 1997. Admittedly, OS 497 of 1997 came to be dismissed while judgment and decree dated 19 to 2002 in the first instance agreed by the same. Second plaintiff have preferred RA 110 of 2002 and though it was allowed and matter was remanded to the trial court, but ultimately the trial court dismissed the suit mainly on the ground that the suit is hit by section 92 CPC. The plaintiff, though again preferred RA 120 of 2010 and the matter was remanded back to the trial court, the suit was once again dismissed while judgment and decree dated 24/2012. At this juncture, it is important. It is of importance to mention
all this judgment is not relevant. You see the provision itself. Law itself is very clear.
Yes, sir.
See, Advocate General or any group of persons want to appoint any trustees, they have to take any permission. If they want to remove any trustees, they have to go to the court. It is not that somebody has filed in a declaration, he need not. He need not to obtain that. This is
But
the
declaration affecting the same thing. My lord, there are three provisions. My lord. One is, my lord, removing any trustee. Second one is appointing a new trustee. Here, my lord, the very appointment is cleverly challenged by way of declaration.
No, whatever may be. See, if any persons who is group of persons are an Advocate General who wants to appoint any trustees,
That's correct.
they can't do it so moto. They have to take a permission under 92. That's what this is only for that purpose.
But for the purpose of removing
See,
also.
That is
Now
not
here indirectly seeking removal only.
See, any part of the subject matter of the trust is situated to obtain a degree, for removing any trustees, appointing any new trustees.
My lord, this has to be read with,
removal means.
my lord, this has to be read with the H condition. My lord, that subsection, my lord, rule H, granting such further or other relief as the nature of the case may require.
This has to be read, my lord. There are inherent powers also, my lord, where it comes.
Directly a
Definitely.
trustee who has
Now-
been removed or a person who has ceased to be a trustee.
H.
Let it to the possession of the property. Directing amount and inquiries. Declaring that portions of the property that owns interest in what is one or any part of the trust property is to be let, sold, mortgaged, or exist.
This is important.
Or other relief as that case may be required. Granting such further.
Granting such further or other relief as the nature of the case may require. Here, my lord, declaration has been sought. ಇದು ಎರಡು ಅಲ್ಲ, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅಲ್ಲ ಅಥವಾ ರಿಮೂವಲ್ ಅಲ್ಲ ಅನ್ನೋ ತರ ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿದ್ದಾರೆ. Cleverly drafted, my lord. To overcome this, specifically they have drafted.
Ruling of this honorable court has considered section 92. Kindly go to paragraph number 76, 27 onwards.
Yes.
27 onwards.
Yes. What does it become to?
Two 2022, volume 1, ACCR. Which both will page 503. To attract the operation of section 92, a suit must be of a certain character and favor certain beliefs. In the first place, the suit should be made with created. In the second place, it must proceed on an allegation either of the breach of trust or of the necessity of having directions from the court for administration of the trust. In the third place, the reliefs claimed must be one or the other of the reliefs specified in the section. And lastly, the suit must be one representative of the mass. These are the requirements. It's only a private dispute between the plaintiff and defendants, wherein when the plaintiff is seeking for a declaration that the appointment of defendants 1 and 2 as trustees by defendant number 3 is illegal and for consequential deliveries. It can never come in the 57 Madras, which I just now passed on to your lordship. It is very clear. Removal should basically presume that the initial appointment should be valid. If initially the trustees are validly appointed, and then a relief of removal is sought, then section 92 applies. If the very appointment itself is challenged, section 92 has no application. That's what the Madras High Court says. Removal provides cannot.
There is one judge, coordinate bench of this honorable court has passed a judgment, my lord, where the declaration has been sought. That also, my lord, their gate has been rejected, saying it is nothing but, my lord, interfering in 92. Yes. But the prayer is, my lord, actually the first defendant in a suit for respect of public trust, namely so and so trust. The relevant portion of the relief column, the plaint, we can declare that trust is absolute owner of the agricultural property, and the present chairman so and so is cultivating the land of the trust property from the date of illegal sale. ಈ ತರ declaration ಕೇಳಿದ್ದಾರೆ. Now, my lord, page 2237, my lord, para 8. Para 8 and 10. Para 8, 9 and 10. Yes. The learned counsel for the revision petitioner next contended that going by the pith and substance of the plaint, the suit is by a public religious charitable trust, inasmuch as the plaintiff's trust was accordingly registered under the provisions of Bombay Public Trust Act as it is then it was. He also took the court through the subject matter of the list and the relief sought for by the plaintiff to show that the subject matter of the suit and the subject matter of the suit under section 92, and therefore a regular suit could not have been filed bypassing the provisions of this section, whose subsection 1 reads as under. But again, my lord, 92 has been extracted. My lord, para 9, the learned counsel for the respondent plaintiff per contra contended that it is in the settled position that the normal rule of law, the civil courts have jurisdiction to try all suits of civil nature, and the jurisdiction of the civil courts under section 9 of CPC can be like to plenary powers to try all suits which involve determination of civil rights, and further that is only requirement is the dispute must be of civil nature and its cognizance must not be prevented by any other instrument of law, either expressly or by necessary implication. The council contended that the ouster of civil court's jurisdiction cannot be readily inferred, and therefore the arguments of the other side as to the ouster of jurisdiction has to be considered very cautiously. Para 10. I have carefully considered the rival contention of the learned counsel for either side. It is true that the jurisdiction of the civil courts under section 9 CPC is all pervasive unless otherwise excluded. It is also true that the courts will normally jealously repel the arguments on exclusion of jurisdiction of the civil courts. But here is
an appointment to the trust. Who are you to challenge? What is your interest? If you want to represent the trust,
According to I'm a managing trustee.
no, he has been removed.
then if you want to represent the trust, then it should be in a permission under 92.
No.
That is what that they're saying.
No. Not only I can fight any suit on behalf of the trust as a managing trustee. And it will come within section 92, provided the reliefs which are sought in the suit are those reliefs which come under section 92. If, for example, if those reliefs do not come, a suit can be filed by a public trust also. Merely because in respect to public trust, the suit is filed. That does not automatically attract section 92. That's what the Honorable High Court has said in the beginning. Unless and until the reliefs which are sought come within the purview, and it should be in a representative character, seeking
But
for
only thing is, the relief should be rejection of the plaint on the ground that he has no locus standi. But the decision is on the other.
The question is this: ultimately, your lordships are considering order 7 to 11 applies. Order 7 to 11 apply or take, and your lordships are aware.
No, that if you have no locus,
No, that's what
then that there is no cause of action. But that is not that contention which we have taken before.
Both, my lord, both twofold contention, locus as well as my lord,
No, my son.
barred by law.
Assuming that they take a stand, but I don't have a locus. That is the stand which they are taking in the written statement. By considering an application order 7, any stand taken by the defendant, either in the written statement or in the application for rejection of claim, cannot be considered. That is the strict rule so far as order 7 to whatever is concerned. Maybe if you file a written statement, finally, if the court comes to the conclusion that I would not have filed this suit, that's a different issue.
Here, my lord, he has falsely contended that he is representing the very content.
That can be decided at this stage,
No,
whether he is
can't
falsely,
yes.
whether he is a trustee.
But that's what happened in the connected matter. While I was reading that RA number 11, my lord, there,
We'll have it on 25th.
Yes.
Yes.
the interim order may be granted, my lord.
Prima facie, I don't think that it will cover under 25th. Yes, this matter on 25th. Or you want?
So at least, my lord, the status quo may be maintained.
No,
Otherwise,
if they pass any order, you can challenge.
no,
it.
that will affect, my lord, the functioning of the trust.
They can file an appeal
But
immediately.
now, he is a totally stranger, my lord.
No, but if it is affecting, you can challenge it. But unless I have been convinced, I can't grant it. If you seeing that section 92, I don't think so. Yes. Therefore, I'm giving one more chance of vacation by changing that roster. Yes, not before. Yes. Yes.
It's a revision petition.
Yes.
Against a decree for 1,34,000.
Yes. Okay.
That's 34,000 is the decree, my lord, with 18%. Lord, I am the owner of the premises, my lord. I let out the premises, residential premises to the respondent. Lord, rent was 17,000 rupees. It was, the lease was for 11 months. Lord, suddenly, my lord, she has taken the lease on October. February end, my lord, she tells tomorrow I will hand over the key. She hands over and vacates it to March 1st, my lord. My lord, under the agreement, my lord,
the lease is required to be terminated with 3 months notice. I did not get any tenants for 6 months, my lord. Therefore, I wanted to set up that 3 months rent, notice rent. But the learned judge has said there is no clause, therefore I can't do it. And my lord, 18% interest is granted. This is a residential premises.
No, that you are that landlord.
Yes, my lord.
No, that why that you have to pay
My lord, that is a house rent deposit, my lord.
deposit.
1,70,000 was the deposit. I
1,70,000. After deducting that, now you have to direct it to pay that remaining amount.
ಇಲ್ಲ ಡಿಡಕ್ಟ್ ಮಾಡಿಲ್ಲ ಅದನ್ನ ಅದಕ್ಕೆ.
Yes, how to issue notice. Yeah, order dated 31st August 2023. Passed by Small Class Court, Bangalore, in SC number 83 of 2021. Okay. Issue notice.
What is the use told for afferent and 29K?
This matter. This interim injunction was not granted, therefore we challenged this at this thing. We produced all the.
Then matter has to be heard finally.
Yeah, that's just.
We'll have it after vacation.
Immediately after vacation, a date may be fixed.
6th November. 6th November. 6th November.
Rakesh DD for afferent connected matter.
Here for petition.
Yes.
Suit for declaration, injunction and partition.
Yes.
Suit for declaration, I filed 2 applications for injunction. One not to alienate. And other one not to construct.
Yes.
Both the applications have been rejected.
But his possession is admitted. Your suit for
Suit for partition, declaration and injunction. He filed against my own son. And his
which
friend.
is that not to alienate? Which is
First one, first one.
First one is
one.
not alienate.
Not to alienate.
Yes. Where is that application prayer? Taking interim order temporary prohibiting the
105.
Yes, how is notice. Parties are directed not to create third party interest in scheduled property till next date of it.
37.1 is connected.
Yes. ಎರಡರಲ್ಲೂ connect ಮಾಡಿ same ಆಗುತ್ತೆ. Yes. Issue notice. Parties are directed not to create third party. Yes. Yeah.
This matter would be taken up on 25th, my lord.
I appeal for the appellant counsel.
Yes.
Facts. So far the possession is concerned, my lord.
Yes.
So far the alienation, court below has allowed the IA and injunction application contrary to the registered instrument in the section 133.
No, suit for
Suit is one for a declaration, declare that the sale deed is null and void, and also
for a plaintiff or a defendant.
I am the defendant before the court bill, first defendant before the court bill.
What is that application he has filed?
That application is not to alienate, not to encumber the property, and also not to interfere with possession.
Yes.
So far, your aspect kindly appreciate. We the first defendant filed a memo before the court below. I am not going to alienate the property. And now there is a triable issue. The court said now there is a triable issue so far the registered instrument, whether it is a documents are genuine or not.
Yes.
Now, when the court says, no, in spite of that one, contrary to the registered instrument, by virtue of the sale agreement and also by virtue of GPA sale deed was executed, later revenue entries are changed.
No, what is this property? Is a site?
Property,
Agricultural land.
agriculture land, madam. 2 acres, 30 gunta. And able, your last kindly in the facts and circumstances of the case, let the trial, the learned judge, trial of
Not to create
within
third
6
party.
months and
My lord, it is not so easy, my lord, because my lord, that cheap, the sale deed is created based on a concocted GPA, my lord, by forging the signatures of the landlord.
No, I'm not.
My lord, for the moment, my lord, I am not alienating. My lord, I am not alienating or they are not alienating.
No, both of them has been.
My lord, in respect of the other application, in respect of the application, my lord, I am in possession of that property. I am in possession of that property. By virtue of the sale deed, he want to try to take possession of that property.
Then maintain status quo. Status quo. You are there.
within 6 months, let them, the suit may be disposed of.
I'll substantiate.
No, if you are in the possession, why do you worry? Then status
Malad, that is not so. For this reason, Malad, there are, after this order, Malad, the appellant herein tried to interfere with my possession. I lodged a police complaint. An inquiry has been done. Malad, where he has given an undertaking that he will not interfere with my possession. Even apart from giving an undertaking, he took his tractor and tilled the entire crop which has been grown by me.
No, that, see.
Subsequently, Malad, another complaint has been lodged. Conduct of the appellant is that, Malad, he being an official, Malad, he is taking into the law into his hands. Malad, one more thing, Malad, the sale deed has been created by him and transferred the property in favor of the brother.
No, we are not on that.
Malad, it's not.
It is only for the injunction.
Malad, there are
Person
two
who is there in
applications.
that to be protected. Now we both are disputing. The only remedy is to maintain status quo. Who are there?
Ultimately, if the status quo is granted, Malad, either of the Malad, he will take advantage of this. Malad, let him not.
Who are in possession, let them continue.
No. That is the Malad, that is the thing.
If this court has granted a status quo, if any parties after that try to interfere, it is then violating that order.
Malad,
Either you have to file a police complaint or
until
file
and unless, Malad,
Malad.
yes, Malad, the status quo, Malad, now the status quo, now the property, who is in possession of the property, he is disputing. Because, Malad, I am not staying in that village. Malad, he is an influential person, he has the police power, and also, Malad, he is an employee of the cities, will put, Malad, I will submit. By taking advantage of this, Malad, he is trying to interfere. Malad, he had killed the, Malad, even though there is an order, Malad, injunction order.
Maybe minister, he may be a chief minister.
Malad,
If there is a court order, if he is violated, everybody has
now
to take
he will take advantage of this status quo order and say that.
different order for different person. Is it?
Malad, for this reason, he takes advantage of this status quo order.
Yes.
And Malad, he will interfere with my position.
See that
You are not
both of them
kindly,
arguing
no, you are not kindly.
Malad, I will argue.
No, you are not
Malad,
kindly.
kindly have this matter on 25th, Malad, I will not seek any adjournment.
Till then maintain status quo.
Malad, Malad, I will undertake, Malad, I will not precipitate. I will not precipitate till then. Malad, 25th, it may be taken up, Malad.
Is this matter 25th till then? What is?
Jail deed is the
Malad,
fruit
not
of-
status quo, Malad, I will not precipitate. Malad, status quo, Malad, he will take advantage.
Jail deed-
Definitely, Malad, he is such an influential person, Malad.
No.
I know, Malad, I
You are
personally have the knowledge.
See, one thing, either you have to argue after hearing that, I will come to the conclusion, or that maintain status quo.
Malad, on 25th, Malad, I will not
Till then
precipitate.
maintain status quo, there should not be any.
Malad, status quo, Malad, he will take advantage. Malad,
No,
not
no,
that-
we-
Malad,
back-
let him undertake, Malad, till 25th. Either of the parties will not enter the possession.
That is the status quo.
Malad,
Exactly.
interview.
No, you are not kindly appreciate, the suit is, the sale deed is 2018.
Yes, Malad.
The suit is filed in 2022.
Malad, how it was, how it has been created.
After
how they
4
say-
years,
how
we
they-
question the legality of the sale deed after lapse of 4 years.
Malad,
Even-
8 signatures have been forged on the
It is
GP.
a matter of adjudication, it is a matter of genuinity. What
That has to be decided by the trial court. I can't
I
say
have no grievance, Malad.
whether that sale deed is genuine or.
Yes, Malad, yes, Malad.
Only thing is,
RTC extracts out of budget, stands in mind and the trial court does not even make a reference to all those.
then that is the only material you have to see.
One
Grant for that 136.
Presumption goes in favor of
Proceedings
the.
has been initiated. 136, 2 proceedings has been initiated. Malad, that has been also been initiated, Malad. Malad, mere entries in the revenue records, Malad, does not say
That is a
that.
presumption.
Presumption, Malad, Supreme Court has subsequently says that presumption cannot be drawn.
No, no.
Malad, based on the title, it has.
Injunction, temporary.
No, Malad, 2023, there is a latest judgment, Malad. Presumption cannot be drawn merely that their
Then-
names found
then
in the revenue
see-
record. Title has to be decided.
No, title has to be decided in the declaration.
Yes, Malad.
Till then, that documents, if it is in a corporation, you have to see that Kata, or that in the revenue records, in the revenue lands, it's RTC. Injunction has to be granted, otherwise judge has to go and see that spot.
Yes, Malad.
Yes.
Malad, 25th, Malad.
Yes. Use this matter on 25th, till that parties are directed to maintain status. 26.
Right.
You are taking notice.
Right, well.
You are taking notice to all.
Appeared. All right, in the other 2 appeals, we are.
Why there are 3 appeals?
Four of these members. Both are brothers.
First defendant filed two of these.
Both are brothers.
It is against that both there is an injection.
Alright, one brother creates a GPA. He executes a sale deed in favor of the elder brother. Alright, one GPA was the GPA.
Who are you? You are
Alright,
not
I am the
related.
landlord.
No, you are not related to
No.
that. Yes.
No,
Then how they have sold your property?
they have not sold.
In
Alright,
91.
1991, they create some one Mallard's agreement of sale. Mallard's taking advantage of 1991 agreement of sale. Mallard's in the year 2000. Mallard's 1998. Mallard's 1998. They creates a GPA stated to have been executed by all the vendors.
No, but
of this
agreement has
property.
been executed by you.
No, Mallard's, I am not executed.
That is also you are disputing.
Yes.
Issue notice. You are taking notice. to the-
Yes, sir. Already. My friend, ಅದು first admission ಬಂದಾಗಲೇ clear ಆಗಿದೆ.
Yes.
ಅವ್ರ R1 to R7 ಗೆ ನಮ್ಮ ಎಲ್ಲ ಎರಡು ನಾಲ್ಕು ಅಪೀಲ್
Parties are directed to maintain status quo till next date of hearing in respect of suit scheduled property. Till next date of hearing. 26.
Yes, ma'am.
Number 49, case Kaleshappa for appellant, connected matter, again Basavaraju.
When we have this matter after vacation only. Soon after vacation.
Yes. At the request of parties, use this matter after vacation. Interim after 2 weeks, interim order granted earlier is extended till next date of hearing. What has happened to that your rejection?
No, that is being argued, my lord. They have to argue the matter tomorrow.
Yeah.
Tomorrow
Yeah,
that is
by 2 weeks, everything will be decided. Yes.
Number 50, people.
Yes. Really, ಆ 4 ಮಾರ್ಕ್ ಕ್ಲಬ್ ಮಾಡ್ಬಿಟ್ಟು ಕ್ಲಬ್ you have to parties are direct to maintain status. Yes, Mr. Deep. Why it is dismissed?
They say that I am not used to talk. Yeah, that I want something. I am only seeking for this. I just want to respond.
So who is that
Nothing, absolutely nothing. I need only a.
records will secure records? Yes.
And the second aspect is, the court says that I have not written. That I want. That I require the law because the entire school, I went to, and actually there is an existing law, it's an enhancement of the law. Yes. Now, under all. But the honorable court has got, in fact, is of this nature. It is a procedural and the inherent person or for regulars. And you see, and it's okay, it's not an evidence. Because says that we have not produced any documents to show that we want money. So therefore, that's only a sole law. And what I have a substantive right to mortgage my property. There's no objection whatsoever. I have established my title and I have also taken off publication. No objection whatsoever has been raised by any property. There is an existence law. And I'm just seeking for an enhancement. Further, the court has rejected.
Yes, that, that final disposal only after securing the records, it's an appeal. Yes, in the appeal. Yes, yes. Yes, heard. Yes, yes, heard. Admit. Office is directed to secure original records from the trial court. Please this matter. The second week of November. Yes, on 9th. Yes, yes. Yes. Yes.
A year. Without even filing application. Oh, my application came to the rejected after 5 years. That is given the finding from the bench.
No, you are suit for, no, suit, no, you are the plaintiff.
Yes.
Suit for,
In the preliminary stage, they were there for the grant. Not really.
when that order has been passed.
That is 2015, 18, right? Separately, order.
Have you produced that order sheet?
Yes, sir. I have a certificate copy.
23-2.
Yes, sir. It is a different agreement.
From alienating and creating any third party interest in this matter. Then after that, what has happened?
The respondent appeared. The first respondent was the beginning, the next party. Thereafter, he filed an application, record, then he filed legal statement. And he was filed adopting the legal statement amendment and the objection. Thereafter, in the 2023. Now,
Yes, where is that? Correct. Well,
implement order page number. What is this number?
yes.
This is the contract providing the essential ingredient for grant of representation. Prima facie the balance of conveyance on the irreparable injury. The plaintiff is also required to establish that it has a strong prima facie case from the undisputed fact in the of injunction. The plaintiff has relied on the registered document to say that that is 2005 and very of secretary is found that the possibility is approved by the proprietor. The DPA holder had executed the agreement of sale in favor of the plaintiff in regard to feasible property, and if they said which is agreement of sale, it is stated that by virtue of the agreement taken 11/4/2009 as the first party, first defendant sees the property has been parking the share of the first defendant, and first defendant is agreed to sell seized property along with the proportionate undivided shares to the plaintiff and undivided rate in interest of the disturbed schedule B. In terms of the schedule, the first defendant has agreed to sell B schedule property for a consideration of 65 lakh, and the class number 2 on the survey line, the document is stated as under. The total consideration of 65 shall be paid to the purchaser to the first defendant within a period of 3 months from this day, and one party shall execute after the sale in favor of the purchaser or any object as per the request of the purchaser. The consideration of sum of 65 lakh as well as advance has been received first party from second party through cash check received to the which has been the first party hereby admitted and acknowledged. The remaining balance of rupees 5 lakh will be received by the first party from the second party at the time of registration of the deed. What the trial court needed the first part and last part. The addition is definitely covered.
No, that you have paid that 65.
60 lakhs.
Then why that quote is not negative?
That is the penny.
Yes.
That is the dispute of because it is my product is blameless. In the said notice, the evidence was product provided. The construction is made in compliance of the condition imposed by the DPA for issuing the sanction plan and completion certificate. In the said notice, it was intimated that the defendant had constructed apartment in a schedule for and condition imposed by the DPA authority At the time of issuing of the sanction plan or the construction, and now the claimant does not dissipate the risk of the opportunity. Is not constructed as an approved plan and become a party to illegal act and it was also paid to the defendant that project of the defendant was not registered with the real estate regulator authority and according to the evidence was brought up to given up to 16 lakh with the liquidated damage of about 5 per month from the date of the payment. The said notice was issued on 4/2/2000 and suit was issued on 15/2018. Consulted as denied execution of contract on the grounds that agreement of sale alleged to be claimed by the client dated on 15/2000 was signed by the defendant. In case of the signature towards the discharge for the purpose of resolution of arbitration from measures and development state country is not. He was a creator of the and if it interest of the multi unit, yes, the same of the state document, no receipt of the payment has
is directed not to create any third party interest in respect of suit scheduled property till next date of hearing. Why? In respect of same respondent. And different properties.
Different flat.
Yes. Yes. Respondents are directed not to create any third party interest in respect of suit scheduled properties till next date of hearing. Yes.
Number 58 is Shamana BA. Number 58, Shamana.
Yes. Yes. So that who are you? You are adjacent landlord or you are claiming another what?
And the property in the same larger extent, more than 70.
Then when you have purchased. Next sir. Absolute sale rate 2021. Where is the class for handing over the possession? Possession is also handed over.
Now, if you have to the past data, not to this property is totally different from the plain property. Very identical property.
Defendants are hereby restraining any temporary injunction violating encumbrance of the future. Is that property you have purchased?
That 760 very large more than 270 acres are land of state.
Which is that suit scheduled property?
What they speak is in the same.
Where is that? Where is the plaint?
Property. The last 26 and the property.
Yes. Issue notice. Day of order dated 13th September 2023, passed by Principal Senior Civil Judge Anekal in OS number 115 of 2024. Subject to condition. Any alienation by the defendant appellant is subject to the result of the suit. We'll have it afternoon.
It's not a null. After admission ಆದ್ಮೇಲೆ ಹಾಗೆ.
Serial number 69 in the mention.
Serial number 60, my lord. Other side, respondent without informing me taken adjournment. I was moved memo because of you, they are not paid the maintenance amount and also.
Serial number?
60, my lord.
60.
Not meeting. Date may be immediately vacation. Because
I have already signed that the consequence.
30th.
30th,
25th, my lord.
27th, 26th or 27th?
26th.
26th. Yes.
Number 59, 1 PM for appellant, VA.
For the. One.
Yes. 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 What's the suit for?
Injunction, mandatory injunction.
Where is that? Yes. Yes. D21. No, 240. Yes. That's what that BBMP has in a power to even that grant and stay also. See that judgment. Yes. 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 Does not create a right in every order to assist the group of things. It is appropriate one. So the concept to the what type of litigation Yes. Yes. Yes, it is followed. Yes.
Yes. Lordship. Respect to only the easementary right is concerned with respect to the errant right, the present judgment is applicable. Your Lordship may kindly appreciate the construction which is going on, which was granted with an injunction order. Third is completed and the sanction plan is only obtained to extent of third floor. Here, fourth and fifth floor has been started constructing completely by going by to the all laws, and there is no sanction plan at all. There is no sanction plan at all. When Lordship may kindly appreciate the order of the court below, is rightly give to a conclusion. at the order portion at page number 31 and 32, your lordship. IA filed by the plaintiff under Article 39 to 1 and 2, Red section 115 of CP. Lord, the defendant is temporarily restrained from carrying out the construction of third and fourth floor till the disposal of the suit, or he till obtains the sanction plan from the defendant for the construction of third and fourth floor, where your lordship admittedly there is no sanction plan at all. If it is allowed, great hardship will be caused to.
No, that is, see, when there is no sanction plan or there is a violation of sanction plan, remedy is under that Corporation Act. That is what that judge said. You are not been remediless. You have a remedy. You approach them. They have also has a power to stop further construction. They can power to demolish also. They have a power to demolish if they come to.
Lordship, there are several judgments where there is a direction.
See,
by both
only
the
thing
court,
is
approach
where-
the court below.
no, only thing is where person who is constructing that, violating the plan, constructing that building, that neighborer land, then you can. If it is encroaching your land and constructing, you can file an injunction. But if he is constructing his land, violating the bylaws, then remedy is to.
It is nothing but encroachment, your lordship. How? I will demonstrate, your lordship. Fourth and fifth floor, they have projected than the portion of their particular piece of land. They have come to mine, and as per the bylaw, they are supposed to leave a setback of 2 meters.
See, and
Where-
also, this is a speedy remedy which has been given under the statutes. If you go to the civil court, by the time you will construct everything, if you approach that commissioner, they could have been immediately issue a notice under 321.
I have already approached your lordship. It is there in the plaint. There is no action taken by any.
Then
the
you can
authorities.
approach this court under 226, seeking a direction. There are number of cases has been filed.
But
Direction.
now,
But civil court is not barred, civil court is barred under this. They can't do it. And also now you are doing parallel proceedings. They are
parallel
also on.
proceedings in the sense, your lordship, my rights are infringed, wherein they have completely given, go by to the 2 meters bylaw, where they are supposed
So
to.
if you succeed, if you make out a case that it is maintainable, you can ask for demolish also. Any construction is always subject to the result. I am not deciding that whether it is maintainable or not, because it is not a suit, final order, it is before me.
Yes, your
Now that there is a prima facie case, that made out that trial court has no jurisdiction for such a order. Either I have to stay it, or I will say that the suit may be disposed of. Any construction is subject to the result. Suit that can be in accordance with law. That's all. You can raise that objection.
It is non-fact. Being the neighbor, I cannot
No,
tie my hand and keep quiet.
No, you have a remedy. You have a remedy under that Corporation Act. That is what this court said.
There are several judgments which is also stated that the remedy is available to the civil court, and it is the triable, once the triable issue is made out, it is the civil court as the jurisdiction.
Even to that extent, before commissioner, once you have given a complaint, you are not in a necessary party and then one judgment. That is between that this thing parties and that commissioner.
My humble submission before this honorable court is that the construction is in such a way that they are coming to the compound wall of
I am
mine.
not saying that they are constructing in accordance with law. We are saying that this is not the forum which is available for you. Yes. Yes, we'll take notice. We'll grant, yes. You are the only BBMP is also there. Yes. Aviator for
Now,
responding.
yesterday I filed Vakalat, GK Shiv Prakash. That is under FR number I have filed.
Yes, yes. Now you will take notice. Yes. So and so learned counsel appearing as an aviator is undertaken to appear for respondent number 1. Issue emergency notice to respondent number 2. Stay of order dated 5th September 2023, passed by 74th Additional City Civil and Session Judge Mehal, in OS number 26171 of 2023 till next date appeal. Yes. Yes. Your husband. Hmm. What are you? What is the reason given for granting such a amount, Mr. In page 30. Yes. Hmm. Yes. Now, what is that income they have considered? What are you? Register and report regarding the loss of business to the tune of 23 lakhs. Now, what is the business you are doing? According to them. What are you doing there? No, you don't have any agriculture land. What is that? How much it is awarded? Yes. Yes. Hmm. 6,000 and 4,000. Yes, sir. Or issue notice. They are dated 9th June 2023, passed by Family Court of Mysore in criminal miscellaneous 319 of 2021, subject to the petitioner, to pay 5,000 rupees, 6,000 rupees to that wife and 4,000 to that son. Yes, as a monthly maintenance. Yes, Mr. What is that reason given in that? On what basis, Mr. The case, what is belongs to that legal class family, petitioner claiming 30,000 per month maintenance. That the respondent is having an Arakanat plantation and he is also having another mobile input property. He is also working. You are working in Dubai. They said you are earning 10 lakhs per month annum. I am responsible for maintaining that the CH mother, no evidence to the effect. Lakhs per month. Profit. It is taken 30,000, 40,000 per month. Agriculture land again hakidara documents. Yes. You pay 50%. Yes. Or notice. Yeah. Or dated 6th July 2023, passed by Principal Judge Family Court, Chikmagalur, criminal miscellaneous 100 of 2022, subject to condition. The petitioner deposit 50% of the arrears of maintenance amount within 6 weeks from today, and is directed to pay 6,000 per month maintenance to that wife. Yes. Yes.
2030. If you live 5 years to the aspect, thereafter they don't from 2019. In view of that, the respondent paid objection only 100 months is paid in the aspect. And she has said, this is before the marriage, which has been proved before the trial court. And trial court has categorically stated that she suppressed the material facts. Can you my lord? In page number.
Yes.
Top 7 page.
Yes.
Therefore, the respondents to the petitioner resulted leave. Okay. Is the petitioner has tried to prove that the respondent and resulted willfully and not provided maintenance. But before that, it is in page number 23. But of what claim? The petitioner has not produced document evidence and proved that after the marriage period, March 2019, she lived with the respondent in Singapore. She solely relied upon 1856 rules of debate, which address of the include is mentioned in the but already pointed out that document has not been put by the petitioner. Therefore, the petitioner has tried to put after the marriage, he lived with the respondent.
Similar matter.
In para 6 million. In para 6. That mentions that submission made on both sides the appearance record from mutual statement of the husband as well as when it is evident that the marriage between the parties was performed at 21 by 1987. Thereafter, they have stayed together for the period of 20. All of a sudden, on 39 2012, the wife left the matrimonial home. Thereafter, no effort has been made by her to join matrimonial. The husband is interested to continue the matrimonial with the wife, and therefore, filed a petition under Section 9 of the Act. The family court in state evidence on the record has made the allowed the petition filed by the husband. So far, the payment of the wife with regard to the payment of the maintenance. So here,
they are order dated 4th August 2023, passed by Family Court Kolar in criminal miscellaneous 48 of 2021 till next date of the report.
Number 2, ethical summary for petitioner.
Yes.
They have released the copy. Section 18.
Yes.
There is not in the
Yes. What is this, Mr.? What is that?
They failed. They failed the indictment. Against the receipt. Came to be execution process remains in present police. Then they failed OS case. That also came. Then they failed SC case. Without serving notice, then they took paper publication. Notice not further. Immediately, Supreme Court says.
What is that now? Which is that execution petition?
Execution is 1060.
Yes. Learned counsel for the petitioner has submitted that office objection has been complied. Office to verify in respect of maintainability. Office objection is kept open. Issue notice day of further proceedings in execution number 2019. Pending in the file of Small Cause Court, Bangalore, till next date of it.
Number 17, Praveen Pasha for appellant.
Complaints. Yes.
The deposit receipt, not the. Yeah, not a. Thanks. Not a. It's like you have to be. Not. The depositor. That's not. In the order of the miscellaneous petition, kindly use. The order was not 43, it says 43. The authority is directed to receive such information. Punishing of such receipt of such information, those depositors are not pleased.
Now that you have filed an application. No, you are not the party. What is that order you are challenging now? Yes.
Order question.
Yes, hereby allowed transfer.
The respondent number 12, offender are permitted to produce the proof of the depositor as investors to be approved. So the petition. There, in lieu of their deposits, investment is managed from this date. Such materials are published. Depositor. Respondent number 2 is the financial establishment. If the deposit is meet in for assurance, then they will return it. Okay, let me do it. In default, this it was initiated with the KRPA. But the ultimate objective was to not the profit to be taken.
Yes,
Auction. And not the money-
distributed to that money to that deposit.
Received it. Right.
Yes.
The of the deposit. But the profit might be disposed not having 85.
No, that now that they have taken the deposit and given a site.
Please.
What is that scheme?
It was on this scheme. Hundreds of people. There were short time not for deposit again.
Then why site are allotting?
Because there was a default. Financial establishment got back into loss. But then the competent authority was appointed by the state, the section 5 of the. That competent authority is actually.
No, why that site has been allotted to you?
The fee of the deposit.
No, it is all the depositors are only for you. No, see, depositors, that scheme is that they will deposit, you will deposit, you will get in a more this thing, interest and all. Why that allotment of the site, which is that scheme? Yes.
Because of that, there was an applicable resolution between the depositor and the financial establishment. But in the like of the resolution, got the reason between them. But it was settled that out of this 354 because of that, for the entry of the deposits, sites will be gone. But the circle side and 100 sites. Okay. Right. There are several other lands also. We got under the process of similar action. That's not the Washington, is not the action for the similar action.
It is your property here. I mentioned that schedule. Where you have mentioned? What is that material to show that it is allotted to you, Mr. By that company? Where is that? Yeah. Where is that sale deed? Now it is not there. When? No, that I, before granting that, I want to see that, therefore I am asking. Pass off, yes.
Number 20, rejects order of opponent, content matter, consequently creates.
With that, yes, you contacted him.
Yes, my lord.
What he said?
Not reachable.
Yes. Your application in that only CRP.
Yes, ma'am. There is no interim order in favor of the defendant before this honor put in the MFA, only NCR.
Yes. Is that matter?
Please. Declaration to declare that scheduled property are joint properties of plaintiff and defendant.
Yes.
Plaintiff and defendants are my lord husband and wife.
Yes.
There is no dispute.
Yes.
I have filed the suit, my lord, before the learned trial court with that prayer, along with my lord IA 39(1) and 2, not to create third party interest, not to alienate.
Yes.
Accordingly, the IA is allowed.
Yes.
However, my lord, they have made an attempt to sell the property.
Yes.
After that, my lord, since they have given for the rent,
Yes.
that is in MFA, my lord, your lordship can kindly there is the impugned order in MFA. Item number B scheduled property and G scheduled property and H scheduled properties, my lord. Running page number 13. 13.
Yes.
Impugned order on IA number 7,
Yes.
which has been filed by me.
Yes.
The plaintiff has filed this application under section 151, correctly the order 39 rule 1 and 10 of CPC, seeking direction to the defendant to deposit the rent being accrued and received from the tenant situated upon the schedule B, schedule G, and schedule H properties. Along after that, my lord, the detailed order has been made. Then, my lord, the honorable court has, my lord, considered the prayer and, my lord, allowed the IA. That is running page number 28, my lord.
Defendant is directed to deposit 50% of the rental amount before the court.
Yes.
That you
Before
are
the
doing.
court, Nangalla, avrige
Avrige.
total deposit madake. However, my lord, he has not deposited. He came and approached before this honorable court. In the meantime, my lord, in the CRP, my lord, he obtained the interim order.
No, what the CRP is filed for rejection of the claim.
7 to 11, my lord.
Why on what ground he sought for rejection of the claim?
There is no cause of action. Since, my lord, the suit is not maintainable, husband does not have any right to ask the property.
Yes.
Since my lord, I am working as a my lord engineer in the USA.
Hmm.
Admittedly, my marriage was solemnized in the year my lord 1978. During the year 1988, my lord, I left the India. And my lord, I have taken my wife and everyone to my lord USA. After that, my lord, I have sent back my wife to India. And my lord, accordingly, I have transferred the amount, earned amount, as stated, my lord, in the lordship may kindly peruse, my lord. It is from 1998 till my lord 2006. I have purchased several property through my lord, my wife. That is running page number 36.
6 in MFA.
Yes, ma'am. 36 in MFA. There is a, they have enclosed the plaint. Wherein, my lord, there is a table.
Why that relationship between that husband and wife is not in good terms?
It was good terms. When I asked her, my lord, when I got retirement in the USA state's government as an engineer, my lord, I came back India. I have asked my lord, we can sell one property. She has said all property is mine, so I don't want to give. When matter was heard by this honorable court, referred to the my lord mediation center. However, my lord, I have made highest effort to the my lord amicable settlement. But wife has refused.
No, is there no issues between them?
There are two children. One is both are doctor, my lord. They are in my lord USA.
They are not.
They are not interested because they are my lord green card holder.
Yes.
From my
No, they are not living together.
No, they are not in India. But we are
No.
husband and husband and wife is my lord same house, one house, but bifurcation is there. The lordship.
No, is there any matrimonial case?
No.
They don't want to live together.
I am aged about my lord 74 years.
No, but that time only they need that partnerships. This thing at the old age only. Both of them has need and help of the others. Yes.
Running page number 36, my lord.
Yes.
The payment, the mode of payment has been, my lord, through NRI. It was transferred. Serial number 1 is, my lord, 10 to 1993. Very next page, my lord. The serial wise, my lord, in total 2,69,008.
Page number
36.
Yes.
Bottom paragraph.
Yes.
First, my lord, payment during the year 10 to 1993.
Yes.
After that, very next page, my lord. 21 item of payment till 25/12/2014. It is in total 2,69,089. 2,69 lakhs 89,240.12 through the my lord NRI. This is admitted fact. No, my lord, she don't want to deposit. She don't want to give any single rupee for me. I am my lord alone. She is my lord.
When the property has been purchased?
When I was in my lord during in USA, my lord.
No date. What is the date?
That is a different date is there, my lord. I have stated.
Yes.
In my lord plaint. The lordship may kindly peruse it, my lord. The scheduled properties, wherein my lord I have mentioned it. Running page number 41. That is my lord plaint.
Yes.
Then my lord, this matter is my lord is posted for evidence. I am waiting to lead my evidence. If they will come up with my lord their evidence, my lord, I am happy to lead my evidence. I may permit it to go with my case.
Yes.
My case unnecessary stalled because of the my lord interim order. Yes, my lord, of course, on by prima facie your lordship may consider, but it doesn't mean that my lord they cannot hold it for ever time.
Yes.
So that my lord, my humble submission before this honorable court, kindly permit me to run my case and let them have my lord ample opportunity to cross me and also lead their evidence also before the learned trial court. Yes. Ultimately, it is the final verdict has to be decided by the my lord learned trial court after completion of the adjudication. My humble submission before this honorable court, I am in the age of the my lord 75, 74 and 75 in the age, my lord. So that my lord, my humble submission before this honorable court, kindly vacate the interim order. I may permit it to go with my case.
Yes.
Please, from 1 year, my lord, I am waiting for to take over my case. However, my lord, it is stalled. I am not able to lead my evidence. Everything I have, my lord, certified copy I have obtained from the competent authority. Now, in the meantime, my lord, they sold the property. That is one more case has filed. That is contempt case also pending. Under section 39(2)(a), I have filed before the learned trial court.
Yes.
They have completely violated the my lord interim order. Now also filed one application before this honorable court saying that they want to sell the one more property, that is a shoe shed property SF. So that my lord, my humble submission, kindly consider the my lord case is there is a cause of action for the my lord the partition suit my lord. It is where is the question my lord, this type of my lord the grievance. The grievance, the entire grievance has been carefully considered by the learned trial court. The learned trial court hold that it's a matter has to be decided on merits, not on the technical reasons. And if it is so, my lord, they have case before the learned trial court to take all contention with respect to the my lord technical contention as well as merits, the merits of the case. If it is on my lord, let it decide on merits of the case. I am ready to lead my case. The lordship may kindly peruse my lord the order in CRP, the very clear order which has been passed by the learned trial court. What was the my lord contention they have taken? And my lord, see the grounds in the my lord CRP. I kindly peruse the grounds. There is no ground for my lord before this honorable court CRP. Please see the grounds which has been urged by the defendant before this honorable court.
Yes.
Running page number 4.
Yes.
Grounds only, my lord. There is no ground with respect to the cause of action, but application is under order 7 rule 11A. All grounds are, my lord, which is nowhere concerned to the my lord subject matter. Grounds is very much silent.
Yes.
There is no specific government with grounds with respect to the my lord the merits of the case. The trial court has fallen to the cleverly drafted the plaint which is without any cause of action which is ought not to have been entertained in the suit. Then my lord Supreme Court judgment was referred. Then nothing is has forthcome in the my lord the order. Purpose of the granted interim order my lord only to settle.
Yes.
However, it has not happened. But their earlier advocate made sincere effort. It has not happened. Then advocate changed by the wife.
Why that they are not appeared before that this thing?
They appeared after the my lord when it is fruitful the result not come over. Then my lord I said take 50, give 50, live and let live. That policy I have employed my lord sincerely. She has not given a single rupee to the husband. So then my lord advocate has fed up earlier advocate. Then my lord he has given NOC. Then new advocate came, he is not coming before the court.
Is that order?
Very senior counsel advocate has my lord appointed as a private mediator. And my lord he has considered repeatedly under different type of my lord mediation. However, it has not happened. And we all went to his office.
She appeared.
She appeared. And, together we are unable to appear, but she was appeared once. When my lord advocate and my lord mediator told that this is the real case, so if you are interested, we will go with. And she has refused. And my lord, I openly stated, I am ready to give the 50%. Take 50%. She is not ready to give one single penny. Even my client is here, my lord, he is ready to file memo before this honorable court. Take 50%. I don't have any problem because she is my wife. Now, wife want to sell one by one property. Therefore, they have made one application before this honorable court.
No, that can't there because there is an stay.
There is an interim order before the trial court.
Yes. Respondent has filed. IA. Number is 20. In CRP 102 of 2023. Respondent has filed IA 2 of 2023 for vacating that interim order. dated 24/2/2023. Court. On 24/2/2023 as take further proceedings in OS number 013 of 2018. Getting on the file of 42nd Additional City Civil Judge, Bangalore. After taking that interim order, counsel for petitioner. Have you served a copy to him?
Yes.
And the counsel for the petitioner has neither filed any objection to that IA 2 of 2023 nor present when the matter is called. Even the matter has been passed over. The afternoon when the matter is called, none appear for the petitioner. Either as a last chance, release this matter on 25th. On that day, if the petitioner, counsel for the petitioner is not present, the court has no other option to pass an order on IA. We'll have it on 25th. That day we will vacate it. Let us see one chance. Yes. Yes.
Nice.
We'll have it after vacation.
Correspondent number 2, Your Lordship.
Yes. No, it will be posted after vacation. Because anyhow that now roster has been changed. You argue before that other court. It is not proper hearing here or there. Any date after vacation? Huh?
Yes.
31st. Leave this matter on 31st.
Obliged, Your
Lordship. Yes, Balangadar after vacation. So many matters I have heard like this. Anyhow that. Any date after vacation?
Date ಬೇಡ
ಬೇಡ.
ಡೇಟ್ ಬೇಡ ಯಾಕೆಂದ್ರೆ ಇದರಲ್ಲಿ ಇದು ರೀಚ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕನ್ಸಿಡರ್ಡ್ ಮೈ ಪ್ರೇಯರ್ ಫಾರ್ ಅರ್ಲಿ ಇಯರಿಂಗ್. ಯಾಕಂದ್ರೆ ಇದಕ್ಕಿಂತ ಹಳೇದ್ ನಂದೇ ಇದೆ ಬೇಕಾದ್ರೆ. ತಾವು ಅರ್ಲಿ ಇಯರಿಂಗ್ ಅಲೋ ಮಾಡಿದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಆಯ್ತು.
ಅಲ್ಲ ಅರ್ಲಿ ಇಯರಿಂಗ್ ಇಲ್ದಿದ್ರು ನನ್ನಂತೂ ಎಂಟೈರ್ ಲೀಸ್ಟ್ ಐ ವಿಲ್ ಬಿ ರೀಚ್. After vacation.
ಅಲ್ಲ ನಿಧಾನವಾಗಿ ಬರ್ಲಿ. My lord, the records have been called for.
Yes.
Now the proceedings are not going before the trial court. Usual course alle ಬರ್ಲಿ. ಇದಕ್ಕಿನ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ. Usual course.
Leave this matter after vacation. Yes.
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋದು ಒಳ್ಳೇದಾಗಿ.
ಬರತ್ ಅವ್ರ ಮುಂದೆ ಕೇಳಿ ಹೊಸ ಕೋರ್ಟ್ ಬಂದ್ಮೇಲೆ.
ಅದೇ ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಅಲ್ಲೇ ಬನ್ನಿ.
Yes, Vishwanath after vacation. Huh? Date ಬೇಕಾ? 9th November. Yes. ಏನಾಯ್ತು? Compromise it's not happened, mister. Huh?
Only some bargain is going on between the parties. I am entitled to 11,500 square feet in item number 2 of the plaint schedule. That apart, I am also entitled to another 700 square feet. Item 1 and 3. A 2 ನಲ್ಲಿ ಒಂದು 11,000 ಅಡಿ ಬರಬೇಕು. 1 and 3 ನಲ್ಲಿ ಒಂದು 7,500 200 or 300 ಬರುತ್ತೆ. My client has agreed to give up that over and above 10. Let them keep it. 10,000 ಅಡಿ ಕೊಟ್ಬಿಟ್ರೆ she will be happy.
ಅವ್ರು ಎಷ್ಟು ಹೇಳ್ತಾರೆ?
ಅವ್ರು 9,500 ಏನೋ ಹೇಳೋದ್ರಂತೆ.
ಅಲ್ಲಿ ಹತ್ರ ಬಂದಿದ್ದೀರಾ?
ಹತ್ರ ಬಂದಿದೆ. ಆಮೇಲೆ in addition to that, they have agreed to give some money. My client has requested for 50 lakhs. Me profits ಗೆ. ಅದ್ರೊಳಗೆ ಏನು ಸ್ವಲ್ಪ ಏನೋ ಬಾರ್ಗೇನ್ ಇದೆ ಅಂತ. ಅದನ್ನ ಕೊಟ್ಬಿಟ್ರೆ we'll put an end to it.
Particular about this negotiation. Yes, the money actually.
ಒಂದು ಚೂರು ಪಾಸ್ ಓವರ್ ಮಾಡಿಬಿಟ್ರೆ ಕೃಷ್ಣಮೂರ್ತಿ ಅವ್ರು ಬಂದ್ರೆ we may conclude it also. There is likelihood of concluding.
ಅಲ್ಲ ನೋಡೋಣ ಈಗೇನ್ ಸ್ಟೇಜ್ ಇದೆ ಅಂತ. ಎನಿ ಅದರ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಲ್ಸೋ ಇಟ್ ಇಸ್ ಮೈ ರೋಸ್ಟರ್. therefore I am just hearing that ಇವತ್ತಲ್ಲ ನಾಳೆ ನಾನೇ ಹಿಯರ್ ಮಾಡ್ಬೇಕಿದೆ. ಆ CRP ದಾದ್ರೆ ಇಟ್ ಇಸ್ ನಾಟ್ ಮೈ ರೋಸ್ಟರ್. ಹಾಕಿನ್ 2 ದಿನಕ್ಕೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಐ ಸೈಡ್ ದಿಸ್ ಇಸ್ ಮೈ ರೋಸ್ಟರ್ ಓನ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ರೆ ಸ್ಕೆಚ್ ತರದಕ್ಕೆ ಕಳ್ಸಿಕೊಟ್ಟಿದ್ದೀನಿ, ಕಾರಿಂದ ತರದಕ್ಕೆ.
ಎಸ್ ಪಾಸ್ ಓವರ್.
ಆಮೇಲೆ ಕೃಷ್ಣಮೂರ್ತಿ ಅವರು ಬಂದ್ರೆ
get your yes. Yes.
For the appellant. I'm for the appellant.
I am trying to find.
ಅವ್ರು ಏನಾದ್ರು ಟೈಮ್ ಕೇಳೋದಿದ್ರೆ ಅವ್ರಿಗೆ ಒಂದು ಅವಕಾಶ. ಆರ್ಗ್ಯುಮೆಂಟ್ ನಿಮಗೆ ಫಸ್ಟ್.
I am filing an application for some out of certain unpleasant events which have taken place. That having the effect of frustrating the very party and also not if a lordship has in my what has happened is this. Admittedly, there are two groups of institutions, Group B and Group A institutions. There was a resolution passed in 2008, pursuant to which Group B institutions have been under the management of my clients, responsible and others. Admittedly, this fact is not in dispute immediately. Even in their written statement before the court, will also have said so. Now, what has happened is, this honorable court has also granted an order while staying the trial court's order. This honorable court has made it very clear that respondent number 3 should not be removed. No resolution should be passed. Remove the respondent, no matter anything with the society. What has happened is this. Unfortunately, one event has happened. Respondent number 3 was accused of an offense under section 301.
You are for the management.
I am not for the management. I am for respondent number 3. I am appealing for respondent. Among the respondent number 3, who has been admitted, he is the general secretary of the society right from inception, right from 2008 onwards, even earlier to that also. And what happened? He was unfortunately implicated in an offense in a case involving section 301. The Sessions Court of the consider the entire matter, and including the fact that all the witnesses had done hostile, including appellant number 1. In fact, appellant number 1 before your lordship is the elder brother of respondent number 3. He has given evidence standing hostile, saying all of them were acquitted. In the state appeal, recently, last 10 days back, this honorable court has reversed the judgment and committed the appellants for the. Now we have already filed it to appeal to the honorable Supreme Court today, challenging the judgment and judgment of the honorable court under section 317 CRP. We have a right of appeal to file. Not specially petition as a matter. Appeal has to come in. In the meanwhile, what has happened? The appellants, despite the fact without even taking the leave of this song, they have appeared, they claim that they have passed a resolution seeking to take over the management of Group B institutions. They are trying to stall the operations of the banking operations.
No, you are the secretary.
I am secretary. Now what?
There others are there with them.
What they are saying is that I have been removed. I am not only the secretary, I am also the chairman of the Group B committee. And I have been managing the institutions all along.
But there is a criminal case, even there is an acquittal, there is no bar for initiating.
As on date, once the matter comes up before the reversal, when the matter comes up before the Honorable Supreme Court, it's quite likely that we not the.
Oh, now you want the adjournment? Yes, you have any.
Not adjournment. My request is.
Adjournment, I have no this thing, my lord.
Let them not stall. Let them not.
Let him finish, my lord. This is a never ending.
Yes, never ending is because you have invited me.
Already when order is passed on earlier, I have to be heard along with final theory.
This is a scenario which has, this application is being filed on account of the scenario created by the appellants without even taking the leave of the court.
No,
This
that
application will have
this
to be considered.
MFA arising out of that.
Interlocutory order.
Can I consider all these things?
How
can that?
My request is this, your lordship may kindly take this application. If
No, you file it that application after serving.
I have already served.
You are served.
My request is I have served the application today. Your lordship may kindly consider, otherwise your lordship may do one thing, I may be given permission to move the vacation. That will be
Yes,
done.
yes, you move that before vacation.
Yes.
Yes. You file it in that.
I will file it in the
Yes. Yes.
lordship may say that I am filing the application in the.
My lord, your lordships don't have to say all such things because. I will tell you why you are not the judge. Please keep quiet for 2 minutes. But it's conviction. He's been convicted for murder.
All right.
of
No, I'm
the-
not
one
asking-
nimsham, for the professor. And under the bylaws, he ceases to be even a member under the bylaws number 34 once you are convicted. And this bench of this honorable court has convicted him. So he is no longer a member even to maintain an application. He wants this court to, so he is filing an application to give it validity. Adala ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅವೆಲ್ಲ. Kindly don't, because my lord, he is not even a member under the one nimsham, please. You are a murderer, you have murdered our professor and administrator.
Wait, mister.
One nimsham iri.
I was acquitted by the.
Alla, don't mislead the court. One nimsham iri. Kindly don't mislead the court.
No, wait, mister, let him make submission when you are making an assumption.
Murderer.
You are.
Let him not call me
High
murderer.
court has.
And it is he, your lordship may kindly say, this particular
This
statement.
matter after vacation.
May I make one request?
Yes,
No,
mister, after vacation.
The
only.
application, otherwise. they
You
put me
go
out.
and move it, mister.
Huh?
You go and move before that vacation bench.
I
See, I am hearing that you are requesting for more.
I am
See, we
sorry,
are
but why I am
doing that,
saying this? Because he's repeatedly calling me as a murderer. That is something which is unfortunate because the reason I am saying, you not kindly take it to the. He is one of the prosecution.
No, see, I don't know that. I am not either deciding that criminal case, not that civil matter, only that application.
Trial court, the suit pending in the.
You reciprocate everything. You take
No,
over the.
no,
law in
Mr.
your own
Counsel,
hands.
you are appearing in so many cases. Can I pass any order in that?
I request you.
See, I can decide whether that order passed by the trial court is right or wrong. Either writ petition ತರ ನೀವು ಒಂದು application
I think I may be given an opportunity to give it claim. My submission is normal course, you are not surprised. But he is a he is a very peculiar circumstance.
No, see,
not
you say, no, that you are seeing that I am not sitting under 226.
I understand.
226, yes, we have an extraordinary.
I will file the application.
You file it, let it be before the court, then we will decide.
My request is. My client is.
First you come out from that, why do you worry about that institution?
Meanwhile, what they are doing, all these group B institutions, which are admittedly practiced by the respondent, even as per their own state case before the trial court. But they want to take over the matter. They want to.
I pray if you succeed, you can get it back.
No, get it back is what.
ನೀವು ಅಲ್ಲಿ ಸಿ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅಲ್ಲಿ ಕನ್ವಿಕ್ಟ್ ಆಗಿರೋದಕ್ಕೂ ಇಲ್ಲಿದಕ್ಕೂ ನಮ್ಮ ಮುಂದೆ ಇರೋ ಕೇಸಿಗೂ ಏನು ಸಂಬಂಧ ಇಲ್ಲ. ಆಯ್ತು, ನಾನೇನ್ ಮಾಡ್ತಾರೆ.
And this gentleman who is making so much of good crime, but he was one of the prosecution witnesses who has done hostile, who has supported my case. Now he calls me murderer. That is
See, you take it after vacation. In the meantime, if you get it in that stay Supreme Court, at least it will helpful for your case to argue. Otherwise,
if required, I will submit it.
Yes.
The lordship is.
Yes.
Because the urgency.
Learned counsel for respondent submits that there is an urgency in this matter. Liberty is reserved to move before that vacation. Yes.
Number 69, Yuvraj Patil for appellant,
Yes, Mr. What is this, Mr.
Matrimonial dispute, lordship. Expert.
Yes. Yes. No, that who has filed the Husband has filed. ಆಯ್ತ್ರಿ ಅವ್ರಿಗೆ ಇನ್ನೊಬ್ರು ಮದುವೆ ಆಗಿದ್ದಾರೆ ಏನ್ ಮಾಡ್ತೀರಿ? No, nothing has been ordered for maintenance or alimony.
Lordship, yes, honorable court. After observing lordship, there is the second marriage that took place. Referred matter to the mediation. By lordship, because of the lordship advice of mediator, has lordship agreed to give lordship after 10 lakhs to the appellant. But lordship, the appellant is more greedy. She wants to claim for 30-40 lakhs.
No, otherwise will not.
There are 3 children. Lordship, may make submission. Lordship.
ಆಯ್ತ್ರಿ ಅದೆಲ್ಲ ಸರಿ. See, once he has taken a degree and he has married, after that limitation period, that cannot be.
Immediately after dismissal petition, without considering the evidence of the survivor, we continue to pass the law.
ಆಯ್ತ್ರಿ opportunity ಕೊಡೋದಲ್ಲ ಒಂದಲ್ಲ 10 ಕೊಡ್ಬೋದು. Now already is married. What you say about that? Can you live together with that another girl? No, if it is married, I think there are a judgment. If it is married, then it cannot be only that the remedy is to, after that degree has been obtained. ಆಯ್ತ್ರಿ ಮದುವೆ ಆಗಿರೋದಕ್ಕೆ ಏನ್ ಮಾಡ್ತಿದ್ದೀರಾ? ನಿಮಗೆ opportunity ಕೊಟ್ರು what will happen now? No, what about that other woman? She has been married.
She was widow. I married her.
You show me that judgment. ಅಲ್ರಿ ಡಿಗ್ರಿ ಆದ್ಮೇಲೆ ಡೈವರ್ಸ್ ಆದ್ಮೇಲೆ ಮ್ಯಾರೇಜ್ ಆದ್ರೂ ಕೂಡ ದಟ್ ಕೆನ್ ಬಿ ಸೆಟ್ ಅಸೈಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ತೋರಿಸಿ ಜಡ್ಜ್ಮೆಂಟ್. ಯು ಆಲ್ಸೋ ಶೋ ಮಿ ದ ಜಡ್ಜ್ಮೆಂಟ್. ಕೊಡಿ, ಏನಿದೆ ಜಡ್ಜ್ಮೆಂಟ್?
The judgment of Honorable High Court of Delhi covers both the aspects.
Why can't you settle that?
I can demonstrate everything, Lord, but in the interest of appellant, Lord, if she doesn't accept it, the 10 lakhs also, Lord, she might not get anything, Lord.
What is that your client is doing, Mr.?
No, Lord. He is working as Lordship for the Lordship, some clerk, I don't know, Lordship, but he earns Lordship about 50,000. Lordship, he has even in the divorce petition, and even Lordship before, even in the petition, objection to the application filed by the.
ಯಾರ ಜೊತೆ ಇದ್ದಾರೆ?
ಇಲ್ಲ, ಎಲ್ಲ ಒಬ್ಬ ಡಿಪ್ಲೊಮಾ ಆಗಿದೆ, ಇಬ್ರದ್ದು ಇಂಜಿನಿಯರಿಂಗ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
ಅವರೆಲ್ಲ ಯಾವ ಬೇರೆ
ಎಲ್ಲ ನಾನು ನೋಡ್ಕೊಂಡಿದ್ದೆ ಎಲ್ಲ. She has also admitted in the cross examination.
ಆಯ್ತು, ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ನೆಗೋಷಿಯೇಟ್ ಮಾಡ್ಬಿಟ್ಟು ಸೆಟಲ್ ಡೇಟ್. That one for all. What is her age, Mr.? She is also aged about 60 years. Then take that money and kept it in deposit and leave for some time, Mr. It will not solve that. It will not.
I can demonstrate. These are the allegations, and she wants to live with the respondent.
ನೀವು ಹೊಟ್ಟೆ ಅಂತ ಇರಕ್ಕಾಗಲ್ಲ. ಈ ತರ ನೋಡಿದ್ರೆ ನೀವು ಮಾಡ್ತೀರಾ ಜಗಳ ನೋಡಿದ್ರೆ ಹೊಟ್ಟೆಯಲ್ಲಿ ನಿಮಗೆ.
I need not demonstrate anything, but in the petition itself, there is ground, and they are Lordship said there is no Lordship conjugality between the petitioner and respondent. They themselves have Lordship proceeded.
No, that divorce is filed under what ground?
Lordship cruelty and desertion. Desertion is constructive desertion. Lordship being in the same house, Lordship there is no cohabitation. Lordship they have themselves have admitted.
But
that
why
is
you
the
are
same
not
ground in my petition.
Third notice when that wife is residing with you only.
That is what constructive Lordship. Same considering the same aspect, Lordship. This honorable court has referred the matter to mediation. Before this honorable court, I am not saying this.
No, that this thing. No, what happened to that notice sent to her?
Lordship, I can demonstrate everything that notice has been served on them. I'm not, this, it's the covered, the judgment which I'm not produced, it's squarely covered. In both aspects.
Yes, Mr. What you say about this judgment law? What is that? Where is that consideration?
Para number 19. Para number 19 starts. Even provision says the irregularity cannot be not
Speaks ex parte against the appellant. We are also of the view that procedure adopted affecting service appellant was proper.
And they have not alleged fraud.
There is another aspect of my review, and if there is an irregularities in the service of summons, irregularities summons, if that is satisfied that appellant had the notice of hearing sufficient to appear reported, so on so. Setting aside the ex parte. The Supreme Court.
Number 19, 20, 21.
Near the irregularity service. No, is it for diverse matter also?
Yes, the same lordship. The trial court has dismissed the application under order 9-13.
Diverse is filed for the court of so and so. All the submission appellant father. When you have married that
Lordship, expect lordship, with there was about 7 days to complete 90 days. And she has filed the application after 7 to 8 months later.
ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಕೊಟ್ಟು ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿ. You know that little problem is also there.
Regarding section 15 that because of the TV. That is what lordship I told.
ಆಯ್ತ್ರಿ 15 ಲಕ್ಷ ರೂಪಾಯಿ ತಗೊಂಡು ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಬೇಕಲ್ಲ ಹೋಗ್ಲಿ ಇನ್ನೆಂತ ಮಾಡಿ. Relax, you ask your client to settle ಮಾಡಿ.
ಅದ್ರ ಮೇಲೆ ಥ್ರೆಟ್ ಕೂಡ ಅಲ್ಲಿ ಹೋಗಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀನಿ ಇದು ಮಾಡ್ತೀನಿ.
ಆಯ್ತು ಅದನ್ನ ಡಿಪಾಸಿಟ್ ಅಲ್ಲಿ ಇಟ್ಬಿಟ್ಟು ಇನ್ see your sons are all they are earning. If you are happy with sons also, they will also take care. Anyway 15 lakhs more than enough.
Application fraud ರಿಲೀಸ್ ಮಾಡಿ.
ಅಲ್ಲ ಆಯ್ತು. You ask her to 15 lakhs. Mediator ಗಿಂತ ನಾನೇ mediation ಮಾಡೋದು. Mediators they are experts, they are not.
ಅದ್ರ ಬೆಲೆ ಕಂಡು
ಹೆಂಗ್ ಗೊತ್ತು ಎಲ್ಲಿದೆ ಏನಿದೆ ವಾಟ್ ಇಸ್ ದ ಪ್ರೂಫ್ ಟು ಶೋ ದಟ್ 1 crore
ಅದೇ ಎಲ್ಲ ಪ್ರೂಫ್ ಎಲ್ಲ ತೋರ್ತಾ ಇದೆ. Their claim is lordship. Some other is getting some amount. That is why he is also getting.
ಮನೆ ಯಾರಿಗೆ?
ಮನೆ ಇಲ್ಲ ಸ್ವಾಮಿ, quarters ಇರೋದು ಏನು ಇಲ್ಲ. ಹೌದು.
ನಿಮ್ಮ ಮಕ್ಕಳು ಯಾರು ನಿಮ್ ಜೊತೆ ಇದ್ದಾರಾ?
ಈ 3 ಜನ ನೋಡಿದ್ದಾರೆ.
ಒಂದೇ ಮನೇಲಿ ಅವಳು ಹೊಸ್ತಾಗಿ ಬರ್ತಾಳು.
ಇಲ್ಲ
ಆಯ್ತು ಏನೋ ಕೊಟ್ಟು ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಇಸ್ ನಾಟ್ ಸಾಲ್ವಿಂಗ್ ಪ್ರಾಬ್ಲಮ್. ಹಿ ಇಸ್ ಆಲ್ರೆಡಿ ಮ್ಯಾರೇಡ್. Then you putting that other women in that problem also, because even you have not filed any this thing.
That is also covered.
After 90 days, getting an expert there, you can add anything this. But even here in the case of nothing, let it prove the case for proven. Let it take reverse.
Already, adrikkinta munche law is that he can marry. He has married. Now, what is the consequence? Can the court to say that again? It has to be said tomorrow. If you say that yes, my cruelty is not proved, then you have been permitted to have a 2 wife. How it is permissible? That is what this, you see that judgment. Ultimately, ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? Appeal is preferred within the period of limitation, even after application and suit was filed after 17 months to expiry of the limitation, despite of the respondent husband solemnized another marriage. We have already observed that no fraud has been committed by the respondent. Summons was also served upon to being the position of law was solemnized by the second respondent was infructuous to all practical purpose from the very inception. So it's present a bit. Keeping the position and application and certificate filed by the applicant day after that second marriage was solemnized by the respondent returned as 6 years for an application purpose. ಅದೇ ಇದ್ರಲ್ಲ ಹಂಗೆ ಅವ್ರ ಮದುವೆ ಆಗಿ ನೋಡಿದ ತಕ್ಷಣ ನೀವು ಬಂದು ಇಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಿ. ಮದುವೆ ಆಗೋ ತನಕ ಆಯ್ತು
ಡಿಲೇಗೆ ಸಪ್ರೆಸ್ ಮಾಡಿದ್ದಾರೆ, ಜುಲೈಯಲ್ಲಿ ತಿಳ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಇನ್ ಜೂನ್ ಇಟ್ಸೆಲ್ಫ್ ಶಿ ನೋಸ್.
ಆಯ್ತು ಅದನ್ನ ನೋಡಿ, ಇಫ್ ಇಟ್ ಇಸ್ ಪಾಸಿಬಲ್ ಯು ಟಾಕ್ ಟು this matter of you when do you want 15th November 15th 10th 10th November yes
Number 70, Rajani Prakash, for petitioner, Rupesh Kumar S.
we have it after vacation before that. This is not my roster from tomorrow onwards.
Where about it? My lordship, she is suffering a lot. She is getting only 10,000 rupees only per month. She is not working at it. In the house.
No, anyhow, that matter has to be finally heard now.
Yes, the son is there. She has to take care of it.
We will fix the date on 25th.
Some enhancement may be passed after being passed. I have written
After that week,
25th, 26th. Interim application is also there.
No, that we finally it is anyhow it is in that hearing. One for all, it will be decided on 26th.
after 30th.
Why after 30th?
Lord, I am not in station during that.
Lordship, one small submission.
Yes.
Because the son's fee has to be paid. He is studying.
Last time
So
said they were
last
paying everything.
Yes, yes.
They had to give now another, I got one more receipt. With great difficulty, she gave 25,000. So
What is
now
that
another
fees?
fee.
What is
So
the
fees
fees?
they should pay at least.
What is the fees?
Fees is per year it is 50,000 rupees. So another 1 year is still there. This year 50,000 she has to pay. 25 she has paid.
Another 25 ಕೊಡ್ರಿ.
Last time ಕೊಟ್ಟಿದ್ದೀನಿ. I have paid already.
Last 2 years I you are paid.
Already I have deposited. This academic year I have already deposited.
ಎಲ್ಲಿದೆ?
I have paid. The receipt
ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
This is again due.
ಅಮೌಂಟ್ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದೀರೇನ್ರಿ? ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
Yes, yes, JD is paid already.
ದುಡ್ಡು ವಿತ್ಡ್ರಾ ಆಗಿತ್ತಂದ್ರೆ ಫಸ್ಟ್ ಕಟ್ಟಿರೋದು. ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಲೇಯಿಂಗ್ ಇನ್ ದಟ್ ಹೈಕೋರ್ಟ್ ಯು ವಿತ್ಡ್ರಾ
ಇಲ್ಲ, DD I have paid DD.
ಡಿಡಿನಾ?
Yes,
So
DD.
this is one for it is with great difficulty she paid 25,000.
Yes, mister. You paid at least 20,000.
Let them give the.
Yes,
What?
I got that. The last occasion, I made the submission, but not she.
Yes.
The son, they stopped.
Wait,
giving-
madam. Your husband is ready to pay that taking care of that wife, not children. He is taking care of children. He is not
No, he
denying.
is not taking care of him. That
No, he said that they will
Last
pay.
time, yes, I have deposited.
No, that
saying-
fees.
Fees I have deposited.
How much you have
1
deposited?
lakh have paid.
1 lakh for fees or this is maintenance?
fees they gave, and fees they gave for the past 2 years. Now another 2 years.
What is he? What is he
He
doing?
studied BBA in Mines of College. And he is another 2 years has to study. This is the third year. And this semester she paid 25,000. Now next semester she has to pay another 20. Per
No.
year 50,000.
No, 1 lakh rupees for
1 lakh rupees for last 2 years.
no,
Per
that-
year 50,000.
no, when you have paid that 1 lakh?
Recently, about 3 months back.
ಅದು ಆಯ್ತು ಅಟ್ಲೀಸ್ಟ್ ಅದು ಮುಂಚೆನೆ ಕೊಟ್ಟಿದ್ರು ಅವರು.
ಮುಂಚೆ ಇಲ್ಲ, 3 months back.
This is the new receipt we can begin the
ನಾನು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳ್ತಲ್ಲ ನಾ ಇಲ್ಲಿ
You go get an instruction from your party. That, yes,
She
and,
not saying I'm
The
not.
son they stopped giving it the maintenance because he became nature. That also I have challenged in this. So 3,000 rupees maintenance they stopped. So only 10,000 he is giving. She has to pay rent, she has to live there. The son is there.
no, he is saying that he is ready, but he will ask the client. Yes. The request of counsel for the respondent.
My enhancement application.
Yes, both will be considered on that day. Yes.
What about these fees?
No, on that day, if he is agreed, he will pay that fees on that day itself. Or that court will pass an order, or will pass an order hearing that matter and dispose of finally on that.
Yes.
Let's say at least it may be finally over.
Yes.
And disposed of.
No, in fact, it is for final
She
hearing
keeps
only.
calling me, I don't know how to reply to her.
Yes. Yes, Mr. Next time there is no
Yes,
problem.
She is suffering a lot. She is.
Yes, release this matter on second.
Yes.
At the request of
The
counsel
fees
for the.
given for this. The video of this receipt given was the next hearing date and not in the name of son. Last time we gave 1 lakh DD in the name of son. So it went to his son's and he put it in his bank. Now he is a young boy of some 22-year-old. So and he is not ready to this. She is somehow made arrangement.
So due to that, mother, Mr.
There is dispute. ಅವ್ರ ಅಮ್ಮ ಮಗನ್ ಮಧ್ಯೆನೆ ಆಗ್ತಾ ಇಲ್ಲ. ನಾವು ಮಗನ್ಗೆ ಅಂತ ಕೇಳಿದ್ರು ಮಗನ್ ಅಕೌಂಟ್ ಗೆ ನಾವು ಡಿಡಿ ತಂದು ಕೊಟ್ವಿ. ಮತ್ತೆ ಅದರಲ್ಲೂ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರೆ ನಾವು ಇಟ್ ಇಸ್ ನಾಟ್ ಆಫ್ ಮೈ ಕನ್ಸರ್ನ್.
No. See, as he earning.
No, not yet.
No,
Wait, madam. Wait, madam. I am putting question to as he earning.
He is not earning.
Then where amount will come for his studies?
ಇಲ್ಲ ಅವ್ರ ಅಕೌಂಟ್ ಗೆ ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದು ಅವ್ರ
ಆಯ್ತ್ರಿ, ಅವ್ರ ತಾಯಿ
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಆಯ್ತು, ಅವನ ಅಕೌಂಟಿಗೆ ಹಂಗಾರೆ ಅವ್ರ ತಾಯಿ ಇನ್ಯಾವ್ದು ಫೀಸ್ ಕಟ್ಟೋದಿಲ್ಲ, ಓದ್ತಾನಂತ.
ಅದು
1 lakh she has to
he
pay.
is not with me, my lord. He is with the mother.
No, therefore you give it to that mother, she will take care of
Yes,
that.
yes.
Ultimately, mother has to take. See, if he is earning, he is not depending upon his mother, then we will say that we will give to that son.
In
He
fact,
wants
he is
that
not
everything
depending
from mother.
ಇಲ್ಲ,
Addition, ಅದನ್ನ ಏನ್ ಮಾಡ್ತಾರೆ, ದುಡ್ಡು ತಗೊಂಡು ಹಾಳು ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ. He is not using for that. What she said is he is in 23 years old.
Yes,
If we give, either that money is not given, it is waste for you also, for him also. Nobody will utilize that.
Yes.
You better give it to her in the name of her.
Yes.
See, mother, even if she use it also, it is for the benefit of the children. Nobody will.
Yes, I agree.
Yes. No parents will that,
Since the child is in this our custody, my lord, I gave the.
Yes, you
DD.
verify. Yes. Second. Yes.
Part of matter, serial number 17, zoning cost of the appellant.
Yes. Yes, Mr. Got that cell.
Settings are not available. Site number 134.
Schedule.
Please note in page 5, in page 5.
This is executed by that.
Not a depositor, not purchased it from the financial establishment.
Establishment is that executed by. Yes. Notice. ಏನಿದು ಇಷ್ಟೊಂದೆಲ್ಲ ಸರ್ವೆ ನಂಬರ್ಗಳಿದಾವಲ್ಲ, ಯಾವ್ದು ಶೆಡ್ಯೂಲ್?
But it is club land, not comprising of several survey numbers.
ನಿಮಗೆ ಯಾವ್ದು ಸರ್ವೆ ನಂಬರ್ ಕೊಟ್ಟಿರೋದು?
But it is not specified as to specifically which survey number not.
Yes, ಕೊಡಿ ನೀವೇ. Yes.
The schedule
Or
also
issue.
reads with all the survey numbers.
Yes, how do you notice? Parties are directed to maintain status quo in respect of ಕೊಡಿ ಅದು.
But this is of site number 6.
ಅದು ಹಳೆದೆಲ್ಲ ಐತೆ ಕೊಟ್ಟಿರಲ್ಲ ಇಲ್ಲ. Directed to maintain status quo in respect of property bearing site number
6 and 134.
ಎರಡಿದಾವ.
Please.
Site number 6 and 134 situated in Devanur extension, Rajiv Nagara, Mysore, called out of survey number 194/13, situated at Devanur village, Kasba Hobli, Mysore Taluk, till next date of hearing.
Grateful.
Subjection.
But I take
Office
the
of-
copy, I will
Council for-
submit it with an ID.
Number Learned Council for appellant has submitted that office objection has been complied. Office to verify. Yes, Mr.
Now.
No, that, yes, Told me that to some extent it is.
Last week currently having tomorrow.
Not tomorrow. Why after vacation?
ಸ್ವಲ್ಪ pressure ಇದೆ.
ಆಯ್ತು tomorrow.
ಅಕಸ್ಮಾತ್ ಆಗಿದ್ರೆ request.
Yes, anyhow that it will be before me once.
ಅದು ಸ್ವಲ್ಪ give and take pressure ಹೇಳಿದೆ.
Yes, tomorrow.
ನಾಳೆ ಹಾಕಿ ಅಕಸ್ಮಾತ್ ಆಗಿದ್ರೆ
Yes.
ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ.
Yes, please this matter.
Statement ಬೇಗ ಬಪ್ಪ ಶ್ರೀನಾಥ್.
Right. ಹೌದೇನಾ?
ಇದು ಹೇಳಿದ್ರೆ ಮಾತ್ರ application ಅಲ್ಲಿ liberty ಸಿಗುತ್ತೆ.
ಹೌದೇನು subject?
ಬರೀ ಒಂದು ಆರ್ಡರ್ ಶೀಟ್